We're live.
Good afternoon. It's Tuesday, the 25th of January, and this is the House Judiciary Committee. Thank you all very much for watching. Members, please set yourselves to mute and only unmute when I recognize you to ask a question. After a witness testifies, you can ask questions by selecting the raise hand feature on your Zoom window. I'll recognize members in the order in which they raise their hands. Witnesses, you'll unmute yourself when I recognize you to present your testimony. After you present your testimony and answer any questions from the committee, please exit the Zoom hearing room. At all times, members of the public will be able to view the live stream of the meeting. The live stream is accessible on the Maryland General Assembly's website. Per our 2020 witness guidelines, 2 of today's scheduled bills will work on the 2 and 1 rule, which is 2 minutes for the sponsor and 1 minute for the witnesses, because they're bills that we heard last year and they're in the same similar posture. Those 2 bills are House Bill 223, and that's Delegate Love's bill. House Bill 225, Delegate Karen Young's bill. And I forgot to make a note of that. So great. So we're going to hear the bills in the following order. We're going to hear from Delegate Cardin with 2 bills, House Bill 183 and 45. Then Delegate Love for 223. Delegate Shetty for 33. Delegate Pippy for 185. Delegate Rosenberg for 127. Delegate Moon for 272 and 209. And then Delegate Karen Young for 267 and 225. So to that end, we will begin with House Bill 183, and Delegate Cardin, please. You are the sole person to testify here.
Thank you very much, Mr. Chairman, members of the committee. This is a bill that I just think is smart policy. I didn't really have anybody come to me, except I do have a neighbor who is a bail bondsman, who I was just talking to a little bit about the no-knock warrant legislation that we worked on so laboriously last year. You know that I had particular interest in that legislation because I had a client who suffered a similar situation as the Taylor case out in Tennessee. And this bill basically prohibits bail bondsmen from doing what we have prohibited law enforcement from doing, which is going into houses, guns blazing, without announcing that they're there. The current law is basically that a person, there are no statutory provisions regarding entry into a residence or location. There are statutory provisions that we passed last year for law enforcement, but there are no comparable provisions for bail bondsmen or their agents, otherwise known as bounty hunters. There is a Supreme Court case where bail bondsmen are given, and their agents and their bounty hunters are given specific authority to be able to collect people as if they were law enforcement. However, I believe that it is both constitutional and appropriate to be able to put some safeguards in there to make sure that they are not doing it in a way that is not safe to any of the parties involved. And so that's basically the bill. Happy to take any questions. If you look at you can see, by the way, the specific language in Taylor versus Taintor in the fiscal note that gives bail bondsmen and bounty hunters the authority to exercise their rights as an agent and go in and imprison somebody who's not following the law.
All right, are there questions for Delegate Cardin? He's the sole person to testify on the bill. Delegate Grammer.
Thank you, Mr. Chair. Good to see you. Thanks for the bill. If I recall, we didn't actually require this of law enforcement. Is that correct? I mean, we didn't actually put in place the requirement to announce for law enforcement. Can you refresh me?
So what we put in for law enforcement is that they have to go in, they basically have to get a no-knock warrant, they have to have it approved by the state's attorney and the judge, and the judge has to very explicitly be provided a description of why it is necessary for them to do it. That's basically what we've put in. There are other safeguards, by the way, that are going to be, I believe that Delegate Davis is going to be introducing legislation to also deal with this further for law enforcement. The goal here is to basically require bail bondsmen and their agents to adhere to the same principles. It can't be exactly the same because there's no state's attorney involved in a bail bondsman going in. However, there can be certain oversight and certain permissions given to simply be able to. So basically what they have to do is, instead of that, they have to announce that they're coming in so that people can not grab their gun and start shooting because they don't know who's coming in and why.
Yeah, and I think the checks are all well and good, but it's about, seems to be about the standard. If a bail bondsman has to announce, I mean, shouldn't anyone coming in have to announce it? Shouldn't the standard be the same?
Bail bondsman is carrying a concealed weapon, or and those weapons can be they're permitted to be any. I mean, I don't think that there's any particular limitations on what kind of weapons they're permitted to be able to carry. You may know that better than I. And so, yes, if in fact they are, I would argue that yes, anybody who is going in with a weapon should have to announce themselves with their weapon ready to go. That would be what I would say. But this bill doesn't deal with that. This bill only deals with bail bondsmen and their agents.
All right, just checking. Appreciate the questions.
Delegate Cham, then McComas, then Erican.
Thank you, Chairman. Thank you for this bill, Delegate Cardin. I had a question regarding, go back to it, page 2 of the bill. It specifies not entering the building, the apartment, premises, or a place or thing. Can you help me understand what thing entails?
Unfortunately, I cannot elaborate on that. Perhaps staff might be able to. A thing may be a specific term of art for a location where the person is.
Sorry.
That's a draft. I would assume that's a drafting inclusion that I just don't know.
I will not. We won't ask counsel to go into that. That may be a question that we'll have to deal with as the bill proceeds. It strikes me that maybe a thing, a mobile home, a RV, something that could be searched. Not.
So I'm thinking, like, if you are at, for example, a venue where it's a stage and there's a back area of the stage. It's not a apartment. It's not a house. It's not a commercial building. Maybe it's a thing.
Well, this issue does appear to be a thing. Delegate McComas.
Thank you, Mr. Chair. Delegate Cardin, it seems to me, and you could disavow me of this thought, but I thought that the last several years, the bail industry has pretty much collapsed in the state of Maryland. And basically, a lot of people are getting recogged. And I guess what I'm kind of curious about is, I do appreciate the need for safety in any type of incident where you're going to get the person that you bailed because you're afraid they're going to leave or something. But I think what I'm kind of concerned about is that the bail industry is part of the whole criminal justice system. And I would like to know if there's been problems in the past with people getting folks that are planning to abscond that have been on bail, and if there's been any incidents of people, violence, whether to the bail bondsman or to the person that was on bail. In other words, I think that it would be good to get some more data about this.
Sure.
And I guess, would you be willing to turn this maybe into a task force to, kind of study what's going on, and whether this is really a serious problem? Because I would imagine that a lot of the bondsmen carry sophisticated insurance for any problems that might arise as well, which would be, possibly injuring someone or being injured because of that profession.
So let me just respond. And the answer is, I don't think it's an appropriate bill for a task force, but I can only respond with the information that I have. I have a neighbor who is a bail bondsman. Yes, the bail bonds industry has been drastically reduced in size because of the changes in the law and the changes in our policy on how we handle bail. That doesn't mean that if there's one incident, because there still is a bail bonds industry out there, if there's one incident where somebody's killed, that's too many people dying unnecessarily. And in the Breonna Taylor case, by the way, you remember that it was just the wrong, they didn't even have the right person or the right residence. So the issue here is one of safety. And my neighbor gave me he said, look, I'm not trying to handicap my business to be able to do what I'm doing, but he's now let's say he's a 60-year-old guy who's a relatively small individual who's got to carry a gun in order to make sure that he can do his business. He's saying, I don't necessarily want to have more rights than the police. I don't necessarily want to have to, because my clients and the people that I do this for want me to collect somebody. Yes, I have to go collect them. Do I want to? Do we want to put people in a place where they're required because of pressures they're feeling from their own industry to have to go and do what we don't even allow police to do because we don't think it's safe for the individuals involved? And my answer would be no. I just think that this is just the right policy. If it needs to be, if there's an issue with, if there's a safety issue following this, then we can deal with that later. But I think this makes it a safer place and a safer environment for all of us to be able to live.
Delegate Erican.
Thank you, Mr. Chairman. Delegate Cardin, could you just explain a little bit more about what the actual bail bondsman process looks like? Because in my mind, when I was imagining a scenario, I was not imagining a scenario where a civilian essentially is allowed to go guns a-blazing, and you would need a warrant from a judge, and there would have to be some evidence that the person was likely armed. I'm not sure that's a bail bondsman job.
Great
I can't
question.
go into a house with my gun drawn.
Great question. So the answer is, with the bail bond, when somebody's out on a bond, it is as if they are they're required to do certain things. If they don't do them, it's as if they are still incarcerated by law. And let me just read this to you. This is from the Supreme Court case of Taylor versus Tatum. When a bail is given, the principal is regarded as delivered to the custody of his sureties, of the bail bondsman, or whomever the bail bondsman is paying for, whoever the surety is. Their dominion is a continuance of the original imprisonment. Whenever they choose to do so, they may seize him and deliver him up to in their discharge. And if that cannot be done at once, they may imprison him until it can be done. They may exercise their rights in person or by agent. Agent would be a bounty hunter. They may pursue him in another state. They may arrest him on the Sabbath. And if necessary, they may break and enter into his house for that purpose. The seizure is not made by virtue of a new process. None is needed. It is likened to the rearrest by the sheriff of an escaping prisoner.
Okay, and that applies to Maryland as well. We don't have any actual laws that govern bail
That's the Supreme
bondsmen.
Court. That's the Supreme Court rendering of what is permitted by bail bondsmen. Now, you can obviously, we can curtail that as long as it meets muster. And that's what I'm intending. I'm not saying that we should get rid of their ability to go collect people when they violated the terms of their bail. I'm just saying that we shouldn't allow people to be able to bust into somebody's house without announcing that they're there with their guns going, because we're going to wind up having deaths like we did in Breonna Taylor. And thank God, not in the case that I handled, but it was a very similar circumstance where luckily all they did was point the gun at the person's face.
So they are allowed to actually brandish their weapon. I just want to make sure that this is actually needed. They're
Yeah.
legally able to brandish.
I asked that question to some bail bondsmen, and yes, they are
Wow,
allowed.
interesting. Interesting. Okay, thanks.
Delegate Davis.
Thank you, Mr. Chair. Delegate Carton, you mentioned that you thought Delegate Davis was going to close up that loophole regarding police officers and no-knocks. And I don't have that bill. Are you willing to expand this one? Or is there a reason why you didn't expand this one? Other than
No, this was really just geared towards bail bondsmen, but I'm always up for discussion. We can talk about that perhaps offline and see if maybe, and maybe talk to some of our committee members and see if there might be an interest in.
yeah, it seems as though there's some
If and we have to talk to whether this is the right vehicle to do something like that. I'm happy to talk to you about it. Sure.
Thank you.
Are there further questions for the bill's sponsor? Seeing none, we thank you all. Thank you, Delegate Carden, for bringing that legislation. That was House Bill 183. We'll now go to House Bill 45. But before we do that, we do have to welcome Delegate Max Lopez to the screen, who is with us here. We want to welcome him. All right, so House Bill 45, again, Delegate Carden. This is a 3 and 2, 3 minutes for the sponsor. There are further witnesses on top of Delegate Carden, just 2 others, CP Hoffman and Robin Murphy. So we'll hear from all of those. If we could have those 2 people there in. Again, Delegate Carden, you're getting 3 minutes. The other 2 will get 2, and we will go right ahead.
Thank you very much. This bill is, let me just, I'm trying to, I didn't prepare, pulled up this fiscal note because I like to have it just in case. So I'm going to pull it up really quickly. This bill is a response to some really good legislation that we passed last year. I think it was last year, maybe 2 years ago. I think it was last year. We passed a bill that basically prohibited the use of the panic defense for particularly specifically for gendered identity and sexual orientation cases. I brought up the issue and thought about this. Why don't we create a protection against the panic defense for all special classes that are enumerated in the hate crime statute? We had decided that it was probably appropriate to hold off until we made sure that we got it done for these specific classes, made sure that those classes were defined correctly in the hate crime statute, so there was no question as to who it pertained to. Now that that is done, I want to revisit it and expand it to make sure that we are also including 3 particular classes that are not included right now in the prohibition of the panic defense mitigation. And those are religion, disability, and homelessness, which are already included in for hate crimes, but they're not included in the panic defense prohibition. That's what the bill does, trying to work with as many advocates as I can. I don't see any reason, I don't believe there's any opposition to this legislation, as there wasn't any to the last one. And I look forward to answering any questions.
All right, we'll hear from the witnesses, I think, first. I don't see any questions now, and then we'll take questions for everybody. The witnesses will each get 2 minutes, and we'll start with CP Hoffman, please.
Thank you, Chair, Vice Chair, members of the committee. I am CP Hoffman, the Policy Director at Free State Justice, which is Maryland's LGBTQ advocacy organization. Those of you who were in the committee last year, you no doubt remember my testimony on behalf of what was then HB 231, the original panic defense bill that Delegate Cardin just referenced. We were one of the major advocates supporting that bill. And in the course of that hearing, the question came up of why is the list here different than the list in the hate crimes bill? And the real answer to that was that the hate crimes bill was also, the Hate Crimes Act was also being amended during last session. And so there were worries that if we amended the language in the panic defense bill preemptively before the hate crimes bill passed, that we would end up with deviations. So there was sort of the decision to move forward and then clean things up now. We are 100% in support of Delegate Cardin's efforts now to bring the hate crimes and panic defense laws in conformance. We believe that there's really no situation where something should be a hate crime and you would still be able to use the fact that you panicked over that person's status as a legal defense in homicide or assault. So we're especially excited by the inclusion of homelessness here. Since there is significant violence against unhoused individuals across Maryland. So thank you for listening, and I ask for your support on HB 45.
Robin Murphy, please, for 2 minutes.
Good afternoon. Thank you for the opportunity to testify in support of HB 45. My name is Robin Murphy, and I'm the Executive Director of Disability Rights Maryland, formerly known as the Maryland Disability Law Center. We are Maryland's designated protection and advocacy agency and a member of the National Disability Rights Network. The national network is composed of P&A agencies and exists in every state and U.S. territory. We were created and funded by Congress to protect and advance the rights of people with disabilities. Our mission is to expand opportunities for people with disabilities to participate fully in all aspects of community life, advance self-determination, dignity, equality, choice, and freedom from abuse and neglect. We fully support HB 45. No individual should be shocked or afraid of a person with a disability. Irrational fears and prejudice should not be acceptable or understandable and should not form a basis for a defense against violence or mitigate penalties, particularly for very serious crimes such as murder. I urge your support for Representative Cardin's bill. Thank you.
Are there questions for the sponsor of the panel?
Great.
Seeing none, thank you all very much. That concludes the testimony on House Bill 45. And we'll now go, if she is here, we're waiting on Delegate Love. All right. How about Delegate Shetty? Can we go to Delegate Shetty's bill? Is she ready?
I want to say yes, but it's up to you.
Well, that's fine. Why don't we go ahead and do that? We will go ahead with Delegate Shetty's bill. There are 2 people to testify, Delegate Shetty and Pam Casemeyer. This is a new bill, so it'll be 3 minutes for the sponsor, 2 minutes for Casemeyer. And yeah, let's go ahead with that, and then we'll find Delegate Love and go from there. Thank you very much. Delegate Shetty on House Bill 33.
Thank you, Chair Clippinger, Vice Chair Moon, and members of the hardest working, best committee, House Judiciary. Thank you for the opportunity to share testimony in support of House Bill 33, which will align Maryland's schedule of controlled dangerous substances with the federal drug schedule while preserving Maryland's existing ability to provide additional safeguards as needed to specific drugs of concern. The DEA classifies drugs, substances, and certain chemicals used to make drugs into 5 categories or schedules, depending upon the drug's acceptable medical use and the drug's abuse or dependence potential. The abuse rate is the determining factor in the scheduling of the drug. Schedule 1 drugs have a high potential for abuse and no currently accepted medical use. Think of drugs like heroin, LSD, and meth, for example, and that can create severe psychological and or physical dependence. It is important to note that as the potential for abuse changes, the drug schedule is changed to reflect that at the federal level. Generally, in Maryland, we follow the DEA schedules of controlled dangerous substances unless the state chooses to add a new one or object to one. Currently, when changes are made to the federal schedule, Maryland must update its schedule each year through legislation. In practice, this means that Maryland's drug schedules are only updated once per year when the legislature meets. However, the federal drug schedule changes whenever it's deemed necessary. The legislature did not make any updates last year to the state's drug schedule, so our state is actually 2 years behind the federal schedule. A disparity between the federal and state schedules translates to confusion in prosecution and to medical providers and pharmacists who reference it. Aligning the federal and state schedules removes an annual legislative burden from us, the legislature, while preserving the ability of MDH to make changes as needed. HB 33 streamlines the process by which drugs are added to or removed from their respective schedules in the state, allowing for the state schedule to be updated whenever the federal drug schedule is updated. I respectfully request a favorable report on HB 33, and I'd be happy to answer any questions. Thank you.
Pam Casemeyer, are you here? Pam Casemeyer?
I wonder if she might not have known that we were going to skip.
She just came in, so we're going to give her a second and then we'll hear from her and we'll take any questions that people have. Pam Casemeyer. I will need you to unmute yourself, Pam Casemeyer. All right, let's do this. Let's see if there are questions for Delegate.
I'm sorry.
There you go. Pam Casemeyer, you have 2 minutes, please.
I am so sorry. I don't know. My screen, my computer's being weird. Sorry.
All right, well, we can hear you and there you are. You're good.
Thank you very much. And I'm sorry for the confusion. As Delegate Shetty said, this bill really is intended to resolve confusion and timing issues that occur with respect to how we now handle scheduling CDS. The bill does not change any of Maryland's authority to object to the federal list or add substances on their own. And in fact, we worked very carefully with the department to try to make sure that the draft maintained everything Maryland's done on its own. But the example I would give, and you have some written testimony in your information on this bill as well, is there was a really good example of how Maryland having to update its statute once a year to mirror the federal statute has potential timing issues, as Delegate Shetty said. And I'm sorry if I'm repeating a little of what she said, because my computer went off for a minute and then I had to get back on again. So Epidiolex, Jazz Pharmaceuticals, which is who I'm representing, is a pharmaceutical company that specializes in drugs for neuroscience and oncology, but has this specific drug, Epidiolex, which has been game-changing for rare forms of epilepsy. Originally approved as a Schedule 5 drug, obviously had all of the control issues related to access and otherwise that should have with Schedule 5. It got descheduled mid-year, which means all of those rules changed. But because it was still listed in our statute, but descheduled federally, it created a tremendous amount of confusion. And in the packet of information you have, you'll see a letter from Johns Hopkins who talked about the challenges of accessing this medication that was no longer scheduled and for which Maryland planned to deschedule the next time you had session. And in fact, Maryland was thoughtful enough and prudent enough to issue a letter saying they wouldn't enforce the fact that it was still scheduled, but clearly that kind of confusion is not helpful. It would occur in the future if something got rescheduled, like if you go from a 2 to a 4, the rules are different. So this bill basically retains Maryland authority, deletes all those names, and basically references the federal schedule so our timing remains consistent. Thank you.
Thank you very much. Are there questions for the panel? Can one of you talk about can one of you talk about when the health department, when the Maryland Department of Health wants to add something to the lists?
Mm-hmm.
Is that done by regulation, or do we have to do that by legislation as well? And how does that interplay with this bill?
So there's a.
Or am I misunderstanding?
No, there's a different section of the law that talks about the state's ability to object or add a substance. And I think there's a process. I know if the federal government takes an action and Maryland wants to object, that can start immediately when they get an action from the federal government. And that's under a different section, which I think is referenced in the state law, because it taught in this statute where it says, their schedules include what Maryland has objected to under another statute. So I think there's a regulatory process where they can object and change those, give notice, and that's under a different section of the law. But yes, they can act immediately and make those differentiations. If you go on the OCSA, which is Office of Controlled Substances Administration website right now, you will notice that they have on that website both the federal schedule and a separate list of things that Maryland has done itself. That would continue to be the case, so Maryland could act separate and distinct, would not have to wait for each session to occur either.
Right. Are there any further questions for this panel? Seeing none, that concludes the testimony for House Bill 33. Thank you both very much for your testimony today.
Thank you. And again, sorry for the confusion with my computer.
You're fine. That's just fine. It's happened to the best of us. All right, so we're going to go now to Delegate Love and House Bill 223. We heard this bill last year. The sponsor, Delegate Love, is going to get 2 minutes. There are quite a few witnesses. So we'll hear from 1, 2, 3, 4. Why don't we do this? We'll hear from Delegate Love and her 5 witnesses in favor, including Scott Schellenberger, Debbie Feinstein, Lisa Jordan, Catherine Marsh, and Lindsay Carpenter. We'll hear from them all together, and I don't see anybody in opposition, so that should be fine. We'll hear from the sponsor for 2 minutes. We'll hear from everybody else for 1. And Delegate Love, whenever you are ready to begin, you go right ahead.
Thank you, Mr. Chair. Mr. Vice Chair, members of the Judiciary Committee. For the record, I am Delegate Sarah Love, here to present HB 223, seeking to close a loophole regarding persons in authority and sexual offenses with minors. Current law prohibits someone who is a person in authority from engaging in sexual acts with a minor over whom that person has authority. But the definition of person in authority is very narrow. It applies only to someone who is employed by or under contract with a school. This does not recognize the reality of our kids' lives, with sports, music, art, dance, scouting, camps, and a whole host of other activities outside of school. The adults leading those activities are in positions of authority, and the law should recognize them as such. The limits of this law are seen on a regular basis by our state's attorneys across the state, and you will hear from them in a minute. I want to briefly share with you the story of my constituent. My constituent's daughter has struggled with mental health challenges. She found an interest in music, and her father, wanting to support her, found her a private music teacher. He drove her to this man's house every week for nearly 2 years. While the father sat in one room, the teacher took the young woman into his soundproof music room. And unbeknownst to the father, during that time, the man was using his position to gain her trust, touch her inappropriately, and ultimately have sex with her. Imagine the family's horror when they learned that this man could not be prosecuted for what he did. If the offender had been the young woman's teacher at school, the state's attorney would have been able to prosecute. This woman and her family are still suffering from this offense. Our kids spend a lot of time with adults who are in positions of authority, not just those who are employed by schools. Those adults should not be able to use that position to exploit our children. I respectfully request that you close the loophole in our law and issue a favorable report on HB 223. Yep, there's my timer. Thank you.
There you go. We'll hear it now from the witnesses. We'll hear first from Scott Schellenberger. All the witnesses for a minute, please. So Scott Schellenberger, please.
Thank you, Mr. Chairman, Vice Chair, and members of the committee. I'm here to support House Bill 223 that expands that definition of person in authority. Criminal Law 3308 has made unlawful sexual acts with a minor when the person's in a position of authority. But for the years that statute has existed, it limited to those who worked for schools. The reality of this day and age in our children is that all of our children have contacts with many more adults than just their teachers. Whether it's a sports team, a music group, an art group, a scout group, you're going to hear from another of state's attorneys and assistant state's attorneys who are going to tell you a story about their particular county. In Baltimore County, we had a case, fencing coach, private fencing facility, offered to drive the 16-year-old home. Parents consented. He would drive her to a remote area where they would have sex and then drop her off at her house. He was found not guilty of all the traditional sex offenses. And because under 3308, he was not her teacher, we did not have the ability to pursue that statute. This is a very common sense approach that needs to expand to the people who are in our children's lives. And I urge you to pass House Bill 223. Thank you.
Thank you very much. We'll go now to Debbie Feinstein, please.
Thank you so much, Chairman Clippinger. My name is Debbie Feinstein. Good afternoon to members of the committee. I am the Chief of the Special Victim Division for the Montgomery County State's Attorney's Office. Delegate Shetty referenced a case that occurred in our jurisdiction. My division reviewed that case a number of years ago involving the music teacher, and the child was 17 at the time. So our other laws did not enable us to prosecute the music teacher for sexually abusing the 17-year-old child. I will tell you that I have heard from this family every year, multiple times since this happened in 2013, I believe it was 2013. And the family is still devastated by the fact that this offender was not able to be held accountable. I will echo what my colleagues have said so far and note that a music teacher in a private capacity should be no differently situated than a teacher in a school. There is the exact same relationship of trust. In fact, because many of these lessons are one-on-one or in smaller groups or develop over years, you have a coach that moves with a team from year to year to year. Those relationships may even be closer. And the opportunity to groom these children and develop that relationship is all the more. I would urge the support of HB 223. Thank you.
Thank you. Go to Lisa Jordan, please.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here to urge a favorable report on House Bill 223. Thinking about Ms. Feinstein's case, let's think about the various laws that we use to protect our children from sex crimes. There was no force involved when the guitar teacher was sleeping with the 16-year-old, so that part of the rape law didn't work. Under the statutory rape provisions in Maryland, 14 is the age of consent for fondling and 16 is the age of consent for anything involving penetration. This girl was 16 years old, so this did not fall under statutory rape. We have a major felony law, sexual abuse of a minor, and that applies to anyone whose family, a household member, or someone who's in care, custody, or under the supervision of a person. The dad in this guitar teacher case was outside the room, and therefore the child was not in the guitar teacher's care, custody, or under the supervision. This is not the first time that the legislature has considered this issue. In fact, I must thank Chair Klippinger for introducing a very similar bill many years ago. 3308 was in fact created to address this Saturday afternoon exception that allowed people to have sex with students off hours, and they added a list of people where there'd be a 24/7 ban on having sex with students. The private guitar teacher is not on the list, so can't be prosecuted. He should be. From the survivor's point of view, it's just as traumatic. Therefore, we ask for a favorable report on House Bill 223.
Thank you. All right, we're going to go to Catherine Marsh, please, for 1 minute.
Good afternoon, Mr. Chair, members of the committee. I'm Catherine Marsh, the Special Victims Liaison with the Charles County State's Attorney's Office. When we consider consent, we look at whether a victim says yes or no, and we forget whether the question should have ever been asked in the first place. When it comes to people who hold positions of authority over a minor, these questions and actions should never occur in the first place. Too often we review cases where a person in position of authority grooms a minor until that minor turns 16 when they engage in sexual acts. When interviewed by the police, we often hear, yep, we had sex with them, but I looked up the age of consent in Maryland and it's 16. If these actions had been committed by a school employee, we would be able to charge. However, when the person is in a position of authority not employed by a school, we have to explain to victims and families why we can't charge. This bill fixes this loophole and brings us closer in alignment with almost 30 other states that have expanded definitions of position of authority. We need to expand Maryland's definition to protect all minors from grooming and sexual abuse, whether the abuse occurs from someone employed by a school, church, sporting organization, or any other youth organization. I urge a favorable return on this bill.
Thank you very much. And the last to testify, Lindsay Carpenter, please, for 1 minute.
Good afternoon, Chairman Klippinger, members of the committee. My name is Lindsay Carpenter. I'm a prosecutor in Frederick County in the Special Victims Unit. I'm here in support of this bill. I have another scenario in which it has discovered this loophole. If there was a martial arts instructor who was grooming a student from a young age, but did not engage in sexual activity with that student until the student turned 16 because he knew that was the age of consent, he would be unable to be prosecuted under the current law. When a parent sends their child to an extracurricular activity, the last thing that parent expects is that their child will become a victim of sexual abuse. Yet we know that's where sexual predators seek employment, as it gives them access to children. So on behalf of the Frederick County State's Attorney's Office and MSAA, I urge the committee to issue a strong message to Marylanders that we will protect our children and hold predators accountable by issuing a favorable report. Thank you.
Thank you very much. I'm going to now take questions for the panel. We'll start with Delegate Cardin, then Delegate Munoz.
Thank you very much, Mr. Chair. And I guess this is for either Lisa or for Scott Schellenberger, whoever can help me answer this question. And I appreciate you guys coming in and supporting this important piece of legislation. In the scenario with the music teacher that Delegate Love, I think, provided, which was very, very troubling, you said that you couldn't prosecute because the father was essentially there, therefore, because he was in, I guess, his custody, because he was only a door away. If that door is locked and he can't, there's no way for him to access, and does the prosecutor have a better opportunity to prosecute on what's presently there? Or is if you're in the present, if you're considered essentially in the presence of a custodian, you can't be prosecuted, because even if they're not aware. Is that my understanding, or can you guys expand on that a little?
So I think what we're all zeroing in on, but needs to be said, is we're looking at the statute of child abuse, and child abuse requires care and custody. It's a very difficult argument to make that the child who is 16 or 17 is in the care and custody of a music teacher when dad's in the house. And so that's the difficult part, is that the care and custody requirement of child abuse statute makes it very difficult when the parents are nearby or have even given permission. And actually, this is why this statute came about in the first place. We were having an impossible time charging teachers with child abuse when we were dealing with 16 and 17-year-olds. You actually had students who would walk home from school, even students who would drive home from school. How are you going to argue that the teacher has their care in custody when they're under those outside circumstances? So that's why we believe this is a loophole in the law. We have this one little spot that we haven't quite covered all the bases, and no one can doubt, as Ms. Jordan said, the influence that these individuals have in our children's lives.
Yeah, and does this help you with teachers as well if we close this loophole?
Well, yeah, I mean, it does, because it could be a teacher in a different role. But, you know, the original statute really was designed for that particular situation. This just closes the whole loop. Anybody who's in a position of authority, and I have to prove that. I got to prove they're in a position of authority over the child.
All right, thank you very much. We'll go to Delegate Munoz and then we'll go to Delegate Fisher. Delegate Munoz.
Thank you, Mr. Chair. Delegate Love, thank you so much for bringing this legislation. If I understand correctly, it's not the first time you've brought this bill before this committee. And as a mother of 4, soon to be 5, I really appreciate your work in this area. And since it has come up before, I just wanted to ask you, what would you say to anyone who is perhaps on the fence or unsure of, the effectiveness of this change in the law in protecting our young people?
Thank you, Delegate. I appreciate the question. Yes, I did bring it last year. I would say that given what I have heard from this father and what I have heard from the state's attorneys when I have talked to them about their cases, and you see state's attorneys from all across the state. We've heard from, St. Mary's all the way to Frederick and in between, that this will help protect our children. This will be effective in protecting them from these predators who, as Ms. Marsh said, seek out these positions so that they can groom our kids for these horrible situations. So I would say that this will be effective in protecting our kids.
Thank you so much.
Delegate Juanica Fisher.
Thanks. Oh, can you hear me? Thank you. Thank you, Mr. Chair. Thank you, Delegate Love, for bringing this. My questions are a bit more technical and maybe someone on your panel, but I guess I really wanted to sort of flush out the different roles and what this bill would do to help close the loopholes that are being discussed. I guess it's on page 2 when it says is under contract with or is a volunteer, intern, paid employee. So would we say that this bill is any aspect of sort of an after school participation? Because, we keep hearing the music teacher or the coach, but would the 19-year-old who's the assistant coach to the soccer team also be within this? And I think those are the things that I think about with all of these scenarios. And I can just say in my home district, for example, there are very young people that are assisting a head coach of a soccer team and things like that. So I'm just sort of wanting to know exactly who is engrossed in this after school. And also, so that's my first question. And then my second question, the bill also says a religious institution on line 12, number 6. So what are the aspects in the religious institution that are going to be covered? That can be all the way from the pastor, the usher, the volunteer that random day. I'm just very where are we specifically encompassing everyone that might be a part of this scenario?
Thank you, Delegate Fisher. I'll start, and then, like you said, we've got the technical experts on this panel, and then I'll turn it over to them. First, it's important to know with your first question that a person in authority by statute right now means a person who is at least 21 years old. So that 19-year-old that you just mentioned isn't considered a person in authority, so it wouldn't apply to them. With that, I'll kick it over for the rest of your answer to my panel. Thanks.
So Delegate Fisher, let me take a shot at that. I think I would suggest that you look at the language that Mr. Schellenberger referred to before, that you have to have a person in authority who in that capacity directs or supervises minors enrolled or participating in the institution, program, or activity. So I don't think an usher would fall under that in a religious environment. However, I do think that if you have, for example, a room where kids are staying and maybe getting religious instruction during regular services, that it would cover that, because that person over 21 would definitely be supervising those minors. So it really is meant to capture people who have that authority over minors, not simply change the age of consent.
Thank you.
Are there further questions for this panel? Delegate Cham.
Thank you, Chair. I think I may have gotten the answer to my question, but just in case, I'll ask anyway. No question is a dumb question. Delegate Love, thank you. Thank you. This is very important legislation. I just wanted to ask, you mentioned the age was 21, and you mentioned that it wouldn't apply to the 19-year-old that might be in authority. Why wouldn't it?
I can answer that. I know that in the good afternoon. I know that in the past, one of the conversations that we had with this committee was the concern that was stated by the other delegate a few moments ago, that someone who is younger may be captured in this type of bill. And so it was sort of a negotiation to make it 21, to be honest with you. Ms. Jordan can probably speak more to that, but really the point was to have the age difference, just like we have with cases of statutory rape and other sexual offenses, where we're looking at a gap between people. So at a minimum in these cases, we're talking about a 17-year-old and a 21-year-old versus a 17-year-old and an 18-year-old, the 17-year-old being of the age of consent and close in age to the potential perpetrator. So it was really a compromise. And also recognizing that that age difference is a distinction with a difference, if you will.
Thank you.
Are there any further questions for this panel? Seeing none, we will end the testimony on House Bill 223. Thank you all very much for being here today.
Thank you, everyone.
Thank you. We're going to go now to House Bill 185. This is Delegate Pippi's bill. He has people who are going to testify. There are 4 people who are going to be testifying on this legislation. So we'll have Delegate Pippi come in. It's a new bill, so he'll get 3 minutes. Then we'll have Joyce King, Joe Riley, Debbie Feinstein, and Lisa Jordan, each of whom will get 2 minutes to testify on this bill. Let's go ahead with Delegate Pippi for 3 minutes. If he's there. Delegate Pippi. Well, Delegate Pippi, I think he's in the room. We just don't have him up. He was here. Give him another second or two. All right, Delegate Pippi appears to be having a technical issue, but we're going to go ahead because the people who are here to testify on House Bill 185, look, it's going to be a little weird because normally he would set things up and then everybody would talk about the bills, but because we have a technical issue and we've got everybody else here, so let's just keep going. So we're going to go first, and we'll give you 2 minutes. And I'll be a little generous on the back end probably if you have to explain a little bit more. We'll start with Joyce King, then Joe Riley, then Debbie Feinstein, then Lisa Jordan. So Joyce King, please, for 2 minutes.
Good afternoon, committee members. I'm Joyce King, Chief Counsel at the Frederick County State's Attorney's Office. I've been prosecuting child exploitation for 8 years, and this bill fills a wide gap in our laws to protect children from sexual exploitation. I've had numerous cases of mothers' boyfriends or even random strangers surreptitiously placing cameras or cell phones to capture naked children in the shower, toilet, bedroom, or dressing rooms. I've watched these videos and seen defendants meticulously positioning camera angles to capture children's genitals. I've reviewed computer forensics that reveal these perpetrators edit these videos, screenshot these videos for photos for their collections. In all the child pornography cases I've prosecuted, I can unequivocally say that there is a correlation between this type of conduct and the collection, production of child pornography, and even hands-on abuse. While sometimes we're able to charge production of child pornography or sex abuse in a minor in these cases, in many instances, visual surveillance with purient interest is the most appropriate charge, but a 1-year penalty is a gross injustice for the serious predatory conduct on children. Even more concerning, last year, the DC Circuit in United States v. Hilly vacated a production of child pornography count involving these circumstances. The court wrongly began to restrict the definition of lascivious exhibition. And I don't have enough time to get into the nuances of the law or the definition. I can follow up with that if you have questions. But the long and short of it is that there should not be a loophole for this conduct, and we must protect our victims. So I strongly urge this committee to issue a favorable report for HB 185.
All right, thank you very much. Delegate Pippi is now with us, and we'll give him the 3 minutes to effectively lead off now. So Delegate Pippi, go ahead for 3 minutes.
All right, thank you, Mr. Chair.
Uh-oh. Oh dear. Delegate Pippi, you froze. Okay. So and he's down again. So we're going to go instead. All right, let's give it one more chance because I think he's going to bounce back into the room. Okay, we're going to go and hear from another witness in the meantime, and Delegate Pippi will be with us shortly. So if we could go to Joe Riley, please, from the State's Attorneys Association. 2 minutes.
Thank you, Chairman Clevenger, Vice Chairman Moon. My name is Joe Riley. I'm the elected State's Attorney for Caroline County and the Legislative Chair for the Maryland State's Attorneys Association. We seek a favorable report on House Bill 185. In Caroline County, we had a circuit court judge who took young boys who were residents of Caroline County to a hunting property in Dorchester County, Maryland, and actually videotaped those young men showering. Even though the incident happened in Dorchester County, I was contacted because of the victims being Caroline County residents. And discussing it with the state's attorney of Dorchester County, we were quite sure that the most that could be charged in the state of Maryland was a visual surveillance with purient intent, which is a 1-year maximum, which in no way encapsulates the harm that was done to these young men and to their families. We believe a felony that has a possibility of a 10-year period of incarceration does capture some of the harm that was done to these young men, and we seek a favorable report.
All right. Don't see Delegate Pippi, so we're going to keep going to Debbie Feinstein, please. Debbie Feinstein.
Thank you. Good afternoon again, Chairman Clippinger and members of the committee. I want to echo what State's Attorney Riley just noted. We see numerous cases like this. One in particular comes to my mind when I think about this type of statutory enhancement for a penalty. We had a case in Montgomery County where an individual whose child attended a gymnastics type of a team event where it happening in a big gymnasium, and then there was a girls' bathroom. That person put a hidden camera in a backpack, and then put that backpack in the bathroom to record the children that were going into the bathroom to use the bathroom during the course of the practice. Incredibly disturbing behavior that certainly warrants something more than a misdemeanor type of offense. When the visual surveillance with prurient interest is targeted at minors, there should be a distinction in the law. And that's the reason that I'm here advocating for this enhanced penalty, to raise the penalty when it's a minor who is 4 or more years older than the child. Thank you so much. I would urge a favorable report of HB 185.
Okay, now we're going to go back and try again with Delegate Pippi for 3 minutes. Delegate Pippi, are you there now?
Dear Lord, I'm going to go very fast before I'm thrown out again. Okay.
Excellent. Go.
2019, this committee passed an excellent bill. Delegate Lopez was the sponsor. It dealt with child pornography. What the bill didn't cover was a scenario where someone puts a camera in a dressing room and ultimately has the same result. That's a misdemeanor. Child pornography is a felony. This bill hopes to clear that up. It only applies to children. There must be a 4-year age gap. It makes sense. It's clearing up a loophole, and it's a real issue. You've got some great folks on the panel. I appreciate the committee's support. Happy to answer any questions. Thank you, Mr. Chair.
Okay, now we'll go to the last person to testify on the bill, to Lisa Jordan, please, for 2 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in support of House Bill 185. And I really just want to echo what the other witnesses have said and ask you all to think about the experience of the minor whose image was captured. And now this image may be posted on the internet. It may last forever. It's extremely traumatic. It's certainly far more serious than a 1-year misdemeanor. For those reasons, we ask for a favorable report of House Bill 185.
All right. This is the panel. We'll take questions for the panel, and we'll start with Delegate Arakan, then Shetty, then Cardin. Delegate Arakan.
Thank you, Mr. Chair. I was just hoping that Ms. King might be able to elaborate. She said that there was another case that was impacting this, and I just wondered if she wanted to expand on that other case so we could have a little bit more background.
Absolutely. There was a DC district case, United States v. Hilly. We do believe it's wrongly decided, and I believe the Department of Justice may be taking it up to an appeal. In that case, the defendant was sexually abusing the 2 daughters of his girlfriend. He was not a resident. He did not share that resident, but he visited every now and again. There was hands-on abuse, and after an investigation, they did reveal that the defendant had installed a camera in the young girl's bedroom and bathroom. And he was convicted of multiple counts of production of child pornography, which had been the practice and has been the practice. The DC Circuit reversed those convictions and held that lascivious exhibition should be restricted and not interpreted by what we have been relying on as the DOST factors, that's DOST. And in that case, they really put the burden on the victim. The court held that the actions of the victim needed to, and I'll just quote it, the lascivious exhibition requires minors to engage in, quote, conduct displaying anus, genitalia, or pubic area in a lustful manner that connotes the commission of sexual intercourse, bestiality, masturbation, sadistic, or masochistic abuse. And, I can't express enough how much we disagree with that holding. And again, that's not our circuit, but we do fear that this type of loophole will be exploited. In Maryland, we have relied on the United States v. DOS factors. And as Delegate Pippi stated, we expanded our definition of sexual conduct to include lascivious display of genitalia. And the factors are more regarding one recording. So whether the focal point of the visual depiction is on the genitals or pubic area, and most importantly, in situations like this, whether the visual depiction is intended or designed to elicit a sexual response in the viewer, which as we described based off of circumstantial or even hands-on evidence that there is, it is for those purposes. It's clear that it's for those purposes. So we just want to close this loophole so these bad cases, don't become law.
Yeah, thank you. Just one more follow-up real quick so I understand. So what kind of impact is that case having? Is this, I imagine it's impacting other states besides just ours. Are there other states that are now unable to prosecute people because the children are not sort of acting sexually in the video that they don't even know is being taken?
Right, so that is the concern. No other circuits have followed it. This is just a 2021 DC circuit case, so it doesn't have, it's not being followed currently, but that's the concern. And I know on the Department of Justice level, because I'm in communication with Project Safe Childhood, it is on everybody's radar.
Okay, thank you very much for that explanation.
Delegate Shetty, then Delegate Cardin.
Thank you, Mr. Chair. Thank you for bringing this bill. I think it's a really important discussion. I just want to clarify. I'm looking at the text, and I'd love to know either from the bill sponsor or any of the panelists, if needed, does the current law or the bill proposed include any place of a home, a residence? Because my read of it doesn't seem to, but I just want to check.
So I actually had a conversation with Lisa Jordan about that this morning. Lisa, do you want to talk about that?
Yes, thank you, Delegate Pippi. Thank you, Delegate Shetty, for the question. This section of the law was a result of the practice of downblousing and upskirting, and so really was talking about people who are kind of out and about. And if you look at page 2 in 5, there's a list of private places, and these are all private places that are not in your home. It does include a family childcare home, but that's not your home. And in fact, I'm somewhat concerned, although I have great faith and respect in State's Attorney Riley, I am somewhat concerned that in the case involving the judge, that was a private hunting lodge. And I think you could make a passable argument that that was a recreational facility, but I'm sure defense counsel would be saying that is a home. So if the committee were willing to look at that and address that issue, you could look on line 12 and item 9, and instead of saying another place of public use or accommodation, you could add private or public use or accommodation. In case you're concerned about monitoring your babysitter or perhaps someone who is caring for an elderly relative, that's already covered. So you're already allowed to take that, and that's at the bottom of page 2 on lines 25 and 26. You're talking about when you're doing visual surveillance of an individual to protect property or public safety or prevent crime. So you would not be restricted from taping your babysitter, taping someone who was taking care of your home. So I do think that would be an important clarification if you are looking at cases like the judge's case, which was so horrifying.
And if I could just quick, Delegate Shetty, we're open to the will of the committee right now as written, and as Lisa Jordan indicated and you obviously observed, is the bill is more geared toward public. But if the committee feels that delineating and adding something very specific to include personal homes, we would be open for that.
I would personally like to see something like that because I feel like even in some of the cases outlined today, it sounded like these are cases that could include surveillance within somebody's home. And so thank you for your indulgence, Mr. Chair, and thank you to the bill sponsor for considering this amendment. Thank you.
Delegate Cardin, please.
Thank you, Mr. Chair. So I just want to make sure I understand fully. So this basically is just an increase in penalties. Is that what the bill does? It doesn't actually change the law in terms of how to prosecute somebody. Is that my understanding?
Correct. So and it focuses on the narrow children. There's got to be an age gap, obviously, but you are correct, and it brings it in line with the 2019 bill that this committee passed.
Right. So let me ask 2 questions. First is, so I have a 18-year-old and a 14-year-old, and the 18-year-old is, because it has to be if it's a 17-year-old and a 13-year-old, it wouldn't apply because it would, right? Because you have to be you have to be of, at least 18 years old or not in order to be able to be prosecuted on this. So let's say you have a 17-year-old and a 13-year-old, and you have the 17-year-old or the 18-year-old taking a picture without the consent or knowledge of the 13-year-old. Putting his camera in her bedroom or putting his camera in a bathroom where he knows she's going to be. There is no demonstration. I don't think the bill says that there has to actually, just has to have a prurient interest. It doesn't say that it actually has to show the genitalia. Does it have to show the genitalia?
So the bill actually lists the parts of the body that it's shown. I believe it says on page 1, 19 through 22, it actually delineates areas: genitals, pubic area, buttocks, female breasts. And then you had referenced something about a private home. We just talked about that. Not sure. Yeah.
Okay. So let's just say for the sake of argument that it shows a woman's breasts. This person can now be looking for up to 10 years in jail for taking that picture. He never publishes it. He doesn't do anything with it. He just takes the picture, right?
So, you know, the prurient intent is it's federal language. We codified that in that 2019 bill, and that is really to separate, and I'll use this as an example, the parents that took a picture of their child in a bathtub playing, you know, that may have shown, you know, the breast area. That wouldn't be considered prurient intent. And the reason they have that word is they want to separate the individuals that are looking to do things for a horrifically bad sexual situation versus an unintended picture. In the bill, actually talks about, yeah.
I understand that. I totally, I mean, I remember all the, this is all new, this is all recent for you in law school, but for me, it was 20 years ago. I remember all the discussions of prurient intent and the Supreme Court discussions about it. Very fascinating. But if he takes a picture of her and the picture meets one of the qualifications enumerated in the law, he doesn't do anything with it. He doesn't actually use the picture. It's confiscated before he even has a chance to put it on his clipboard or whatever he's going to do with it. He still is on the hook, potentially, having never, all he did was take the picture without her knowledge. He now could be on the hook for up to 10 years. Is that, I just want to make sure we know what we're talking about here. So
Sure. Well, this bill deals with surveillance. It doesn't deal with distribution.
Right.
And that's correct. So what we have is, you know, again, I feel it's my personal responsibility to look after those most vulnerable. In this particular case, children. So when you have someone that is intentionally and with prurient intent taking and surveilling highly sexual and suggestive photographs of children, whether they decide to post that, send that, share that, text that, whatever, once they commit that initial act, yeah, that's a felony. And ultimately a judge or a jury will decide whether they want to move forward. You know, but what I want to do is make sure that we separate an individual that's doing this to children versus an individual that may have done that at, you know, Macy's changing room, you know, to an adult. And I think this is in line, again, with the legislation that we've passed in this committee before. And I think it's valid because children are the most vulnerable. And we see this over and over and over again. And what I really don't want, and really the precipice for this bill was that I don't want a guy who's like, oh no, I just put the camera in there. It's just a misdemeanor, no big deal. It's like a loophole, you know, it's a defense. And we don't want them to have that defense. And I think that's what this covers.
And if I could just interject and echo Ms. Jordan, with all due respect to Delegate Cardin, I think something that we see often, I've had to speak with victims about 13, 14, 15-year-old victims, is that there's a minimization of this type of conduct, that it's not really harming these girls, but it deeply does. And I've had to sit down with many victims that are traumatized, that are deeply disturbed, violated, and don't feel safe in their own homes because of this type of behavior that was conducted. So I just did want to put that on the record.
All right. Are there any further questions for this panel? Seeing none, we thank you all very much, and that concludes the testimony
Thank you.
for House Bill 185. We're now going to go to House Bill 127. I am looking for, there he is, Delegate Rosenberg. This is a new bill, and there'll be 3 minutes for the sponsor, 2 minutes for others who seek to testify. I have 3 that are speaking. Well, let's do this. We'll hear from Delegate Rosenberg, then take questions. Then there are 3 others who are going to testify from the Department of Public Safety and Correctional Services who are testifying in an informational capacity. So if that's all right, Delegate Rosenberg, we'll hear from you for 3 minutes, then we'll take questions, then we'll hear from them each for 2 minutes. So, okay, here we go. Delegate Rosenberg for 3 minutes.
Thank you, Mr. Chairman and members of the Judiciary Committee. Yes, this is a new bill, but it is a new bill that makes a minor but important addition to existing law, to the law regarding the longitudinal, Maryland Longitudinal Data Systems Center. As Senator Moynihan once famously said, you're entitled to your own opinion, but you're not entitled to your own facts. And we created this center to have a resource for the state and the public with regarding information regarding state agencies and so on, state departments. And what this bill would do is add to the agency data that can be used by the center, data from the Department of Public Safety and Correctional Services. Individuals' identities would not be made available. That is the case under existing law. And policymakers would be better informed regarding strategies to address the prison population and what services that are provided have a more positive impact when someone is no longer incarcerated. When is it more or less likely that the person will return to prison, will commit another crime? This legislation, I introduced it at the request of the ABLE Foundation, which does extensive research on a host of issues that are of benefit, and its work is of great benefit to the citizens of this state. They wish to do further research regarding people who are incarcerated and what programs better assist them in returning to the general population. This bill is needed. Under the current law, they were unable. ABLE was unable to obtain certain information. We have already begun discussions with Department of Public Safety and Correctional Services, the ABLE Foundation, and the Longitudinal Study Center as the extent to which legislation is needed and also the extent to which legislation is permitted, as there is federal law in this area in addition to state law. So to further serve our ability to adopt and implement sound public policy regarding people in the custody temporarily of correctional services, I would urge a favorable report on this legislation. Thank you.
All right, thank you very much. Are there questions for Delegate Rosenberg? I think we're joined. Are we joined by another committee? Is this a? Yes, it's joint with the Ways and Means Committee. So there are members of the Ways and Means Committee who are here with us. I see Delegates Guyton and Carr, and there's probably a third that I just can't see on my screen who I now have offended. So we can just, I will live with that. I apologize. We'll go and Delegate Rose. There we go. All right. So questions for Delegate Rosenberg? All right. No questions for Delegate Rosenberg. We'll go on then to the next panel. We'll hear from 3 people, each with 2 minutes, all from the Department of Public Safety and Correctional Services. Jennifer Beskid, Stuart Nathan, and Angelina Guarino. If we could hear from Ms. Beskid, that would be great for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of both the Judiciary and the Ways and Means Committees. My name is Dr. Jennifer Beskid, Director of the Office of Government and Legislative Affairs. And with me today, as stated, is Ms. Angelina Guarino, the Director of the Office of Data Development, and Mr. Stuart Nathan, Assistant Attorney General, who is here to answer any questions. I'm here today to provide testimony on House Bill 127. The Department's Division of Correction operates 13 state correctional facilities that house offenders sentenced to incarceration for 18 months and longer. House Bill 127 proposes the Division of Correction provide correctional services data to the MLDSC. The proposed definition of correctional services data is broad and refers to arrest and incarceration data. The Division of Correction does not have arrest data. Additionally, the proposed definition includes criminal history record information, and the department is prohibited from sharing this information by both state and federal law. The bill includes existing language that established the MLDSC as a central repository. Correctional services data is not student or workforce data, and the Federal Bureau of Investigation does not allow the creation of many repositories of criminal history record information. The Department of Labor provides educational services for incarcerated individuals participating in GED programs. Therefore, educational data should be provided to the MLDSC by Labor and the Maryland State Department of Education. However, we have met with the bill sponsor and MLDSC and have drafted some amendments. We would be happy to continue working collaboratively on this matter. And with that, I will turn it over to Director Guarino.
Go ahead.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. My name is Angelina Guarino, and I'm the Executive Director of the Department's Office of Data Development. The department utilizes an offender case management system, OCMS, which is an integrated case management database that compiles information about an incarcerated individual throughout their time in state custody. House Bill 127 would require a large-scale replication of the data that's currently maintained in the OCMS. Continually culling that volume of data would be labor-intensive and redundant for both DPSCS and MLDSC. On an annual basis, the department can currently generate and share a report with the MLDSC that contains a breakdown of individuals released from the Division of Correction within any given time frame that includes their age, gender, race, offense type, sentence length, and type of release. The department is not able to share personal identifying information in bulk, such as name and date of birth, as this is a component of criminal history record information that cannot be maintained in a database by a non-law enforcement agency. We would also note that the correctional services data that's being requested in this bill would be incomplete, as the department's data only includes individuals sentenced for over 18 months. Individuals with shorter sentences are housed in county-run local correctional facilities, and they represent a significant portion of justice involvement, which would impact the accuracy of local outcome measurement. The department understands MLDSC's mission of providing accurate student performance and workforce data with the goal of improving the state's educational system. We will work with the MLDSC to provide data on incarcerated individuals that can be shared in a more limited and usable manner. This partnership could be accomplished already without legislation through our existing research process, just by entering into a data use agreement, as the department has already done with independent researchers and other state agencies looking to evaluate long-term outcomes, such as the Maryland Department of Health and the Administrative Office of the Courts. With that, I request that the committee consider this information, and we're happy to answer any questions that you have.
All right, Stuart Nathan.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name's Stuart Nathan. I'm Principal Counsel for the department, and I'm available to answer if there are any legal questions. I think most of the legal issues have been at least touched on by the previous witnesses.
All right, are there questions for this panel, please? Questions for the panel? All right. There are no questions for the panel. Then that concludes the testimony for House Bill 127. And we thank the delegate. We thank everyone for coming here today. If there are questions that people think of later on, they can direct them to the delegate and or DPSCS. Thank you very much. All right, so now we're going to go to the first of two bills from Delegate Moon. This first bill is a new piece of legislation, sort of, but it's a new piece of legislation mostly, and it'll have 3 minutes of testimony for Delegate Moon, and then 2 minutes for those people opposed. Or I'm sorry, 2 minutes for those people both in favor and opposed. There are 1, 2, 3, 4, 5, 6, 7, 8 people who are here to testify in favor. So what we're going to do is we will hear from the first 4 witnesses on the list along with Delegate Moon. Then we'll hear from the second panel. So that'll be Delegate Moon for 3 minutes, then 2 minutes to Carrie Williams, CP Hoffman, Lisa Jordan, and Steve Kroll.
I think you've skipped to the second bill. Because I think
okay. Oh, that's 209.
Yeah.
Never mind. Let's try this again. Actually, our next bill, everybody, is House Bill 272. And someday I'll just never, screw up. Sorry. House Bill 272 doesn't have nearly as many witnesses, which means that it'll probably be twice as length of the hearing and will go on all day. Delegate Moon is going to be joined by Scott Schellenberger and Jake Burdett, who are going to testify on House Bill 272. And so we'll just hear from all 3 of them, 3 minutes for Delegate Moon, and then 2 minutes for the other 2. And I will live in shame for screwing up. So there we go. House Bill 272, Delegate Moon, Vice Chair.
Thank you, colleagues. Thank you, Mr. Chair. House Bill 272, it's a very simple bill to reclassify essentially eavesdropping, criminal eavesdropping, from a felony to a misdemeanor. The bill does not change the penalty, which would remain at up to 5 years in prison and a $10,000 fine. So again, if you tape a conversation with someone without their consent, you can get up to 5 years in Maryland, and this bill won't change that. But I do think this was an improperly classified as a felony. The range in penalty up to 5 years might reflect the range in types of cases impacted by this bill. It's everything from Linda Tripp taping Monica Lewinsky to domestic violence victims trying to prove their abuse by taping it, to Roy McGrath taping conversations with the governor, and to someone you might hear from today who was in a meeting with their member of Congress's office and continued taping when they were asked to stop. Again, none of the behaviors I described above was legal or would be made legal by this bill. However, classifying all of these as a felony is improper. You heard earlier today, in fact, moments ago, that taping a child's shower room is a misdemeanor. And all of the things I mentioned above, which again include someone taping in their member of Congress's office or a domestic violence victim trying to prove their abuse by taping it, all of these things are currently classified as felonies. A felony conviction in Maryland, and I actually went through the code and looked this up again. You can be barred from becoming a barber, interior designer, plumber, landscape architect, from holding a liquor license, engineering, or forestry in Maryland. That's in law if you have a felony. If it's a misdemeanor conviction, it only applies if it's related to your job. So in other words, you tape your member of Congress, you can be banned from being a barber in Maryland. So that, voting rights, problems with student loans, I could keep going on and on. Again, simple step. I'm just asking that we reclassify properly this as a misdemeanor and not a felony. It's out of whack, and it treats and disrespects the seriousness of the crimes of violence and other things that we do want the felony label to attach to. So with that, I'll turn it over to my esteemed panel.
Helps to be unmuted. Go now to Scott Schellenberger, please. 2 minutes.
Chair, thank you so much. Delegate Moon, thank you for putting this in. For the delegates who don't know, I started testifying to get rid of this wiretap statute in the 1990s. I was a child abuse prosecutor. I had an audio recording of a victim of child abuse who recorded her grandfather abusing her. And I could not play that audio recording in a courtroom because of a statute that still talks about switchboards and wires. This is a vestige of an old past time that we must get rid of. How many times do we see bad things on TV news now, and the first thing everybody does is pull out their cell phone and record? And in Maryland, if you do that and record audio, you have committed a felony. We need to pass House Bill 272 and bring us closer to the modern age. Delegate Moon and I have tried for years to completely get rid of this bill, this statute. Maryland is a two-party consent state. The majority of states are one-party consent, which means that in other states, when they pull those phones out and record, say, a police officer abusing someone, which ended up leading to convictions in this country, in Maryland, if you pull that phone out and audio record, you are committing a felony. I salute Delegate Moon for let's taking a baby step instead of the giant steps we've tried to take before. But now is the time to make Maryland at least come into the modern age by lowering the crime down to a misdemeanor, so it is a little bit less severe, but doesn't change the penalty, which means the people who are currently pending charges on doing this could potentially go to jail for 5 years. I urge a favorable report finally to take this step forward.
All right. Committee, your computers are working properly. That is Delegate Moon and Scott Schellenberger on the same side of the bill. Jake Burdett, are you in the waiting room?
Yes, just one moment, please.
Okay, we'll hang on just for a moment. And when you are ready, we will give you 2 minutes to testify to the committee. And I'm going to keep talking until there you go. All right, Mr. Burdett, please, for 2 minutes. If we can hear you, that'll be perfectly fine. We did.
Can you hear me?
Yes,
hello?
Go ahead.
Okay. Hey, good afternoon, Chair Clippinger and members of the House Judiciary Committee. My name is Jake Burdett, and I'm testifying today in support of Vice Chair Moon's bill HB 272, which would make Maryland's interceptions of communications penalties a misdemeanor rather than a felony. This is a bill that is very important to me personally because Maryland's current archaic and overly punitive wiretapping laws have negatively impacted my life in a major way. More specifically, I was in a very high-profile and controversial case in 2018 during my time in college at Salisbury University, where notorious Maryland Congressman Andy Harris pressed felony wiretapping charges against me for live streaming a protest at his constituent office without the consent of his staffers. Despite widespread bad press resulting from this authoritarian move, I was still facing a potential 10 years in jail for this, as well as two felony charges. Although I was able to avoid any jail time by taking a probation before judgment plea deal, and I was not actually convicted of any felonies, just having the felony charges on my record at all has continued to follow me around for my young adult life and make it very difficult for me to find meaningful employment, and has also served as a scarlet letter for my reputation. Unfortunately, there's a lot of stigma around the word felon, as I've learned the hard way, and many employers just outright reject any potential applicants based solely on having any felonies on their record, regardless of what the felony even is. This is often done through automated background checks, which reject applicants even if all they have is a felony charge but no convictions. Because of my felony charges, I faced hiring discrimination from employer after employer for jobs I was actually qualified for. And as a result, I had no choice but to work in an Amazon warehouse during the height of COVID, as they were one of few employers I could find that did not do background checks. It is a shame that the label of felon carries so much negative weight in the eyes of employers and society at large. And as long as that is the case, I think we should reserve that label for only the most heinous of crimes, such as murder, rape, and other truly abominable acts. I do not think live streaming a protest in a public space should warrant that label or level of punishment, though, nor should it apply for an abuse victim covertly recording evidence of their own abuse or any other number of circumstances where it would be completely justifiable to record someone without their consent. In fact, Maryland is one of only 12 states where it's illegal to record
Mr.
someone
Burdett?
without their consent in the first place.
Mr.
Yes.
Burdett, if you'd wrap up, please.
Yes, last sentence, sorry.
All right.
Maryland is one of only 12 states where it's illegal to record someone without their consent in the first place. So I think based off that norm, the penalty should be minor if we're going to make it a crime at all. Thank you.
Thank you very much. Now we'll take questions for the panel, and there are several. We'll hear from delegates Cardin, then Juanica Fisher, Arakan, Grammer, and McComas. We'll start with Delegate Cardin, please.
Thank you very much. And thank you, Vice Chair Moon. I've supported your efforts to try and get rid of this statute altogether. My question is, why are we not reducing the penalty as well? I mean, it could still be inadmissible in court. It can still be illegal to do, but so you can create problems with people's records, like Mr. Burdett, who would still possibly have a misdemeanor record if he didn't get the PBJ. But why are we giving people up to 5 years instead of maybe like a 60-day type thing, where there's no reason why people should be serving jail time for recording other people?
Thank you for the question. I'm not going to lie, and especially when you line it up to the lower jail time and misdemeanor status of taping a child's shower, it seems all the more out of whack what we're doing here. I had this bill drafted when the McGrath case was hitting the news. And so there were a lot of questions about how far we would be able to take reform on this topic while big cases like that are pending.
It's not pending, though,
I'm
is it?
entirely comfortable to broaden the conversation. I would just ask if the committee wants to head in that direction, let's tap our friends across the street in the Senate on the shoulder and make sure they're ready to take the same leap with us. If not, then I think, as the state's attorney mentioned, we might be in for doing this in a few steps.
Delegate Juanica Fisher.
Thank you, Mr. Chair, and thank you, Vice Chair Moon. It's my, I don't know if it's my first time saying that. I think it's your first bill. So yeah, it's really exciting. And thank you, Mr. Sullenberger, as well, for your work on this legislation. Mine was, Cardin sort of took my question, but my follow-up was, when it comes to victims of like sexual abuse or domestic violence, were you thinking about I understand the political compromise of let's just make it all a misdemeanor, but were you thinking for maybe those incidents that we could do something in the bill that they would not be charged in those incidents if there was another crime that was found, at least, the victim that they were a crime of, was pursued or something like that? Or you just think right now both chambers wouldn't be open, at least for me?
That was a bill last year, so I think
Yeah.
I tried that last year.
And it
This bill last year was actually far more expansive. It included a way to bring evidence in, as well as some of this other stuff. And that was cross-filed, I think, with Senator Lee, and she's bringing back a version of that bill, which I need to get back to her, in fact, on whether I'm going to cross-file that. So that topic is, in fact, before us this session. But again, it was our friends across the street in the Senate that moved nothing on this last year, which is why I think we started reevaluating what was going on and what was possible. So if you have a second, you might want to call over to our Senate friends and figure out what's the holdup.
Okay, thank you, Mr.
Delegate Fisher. I can concur that the bill last year was more robust and had the exceptions that we needed. But again, we got nowhere. And so I know Delegate Moon has been trying to make moves on this, maybe not as long as I have, but clearly, if you can convince your colleagues in the Senate that we have that call-out exception for sexual assault, child abuse, and domestic violence, I would be very happy to help and support that and testify in favor of that.
Delegate Erican, please.
Thank you, Mr. Chair. Thank you, Mr. Vice Chair, for bringing this bill again so we could talk about it. I think, some of the testimony was interesting. Protests, as we've learned in the last year or so, are in the eye of the beholder these days. I've personally had people come into my office, ask to record me. I've told them no. They've recorded me anyways, and they've posted that stuff online. They were so ignorant, they posted the wrong tag and the wrong county. But that stuff literally happens, and it's totally disgusting. So my question to you is, I understand that you think this bill should have a lower penalty. Would you be willing to make the previous bill a felony?
I think either way you cut that other bill, this is incongruous. So this needs to be dropped to a misdemeanor, regardless of whether we move the other penalty, because this is the lesser offense, right? Taping a child, if you want to hold taping a child's shower room up as a misdemeanor or a felony, this is a lesser offense in either case, in which case that means it ought to be a misdemeanor. As to the scenario you're describing, I'm sorry to hear about that, but again, the penalty wouldn't change. It's really about whether you think someone should per se be, again, based on having done that to you, they can't be a barber. I'm just not sure what the nexus is there. Again, if it's a misdemeanor conviction, it has to be related to them being a barber. If it's a felony, it doesn't have to be related at all. And that's just one example, but just this. So again, if we want to treat the other things seriously, I think we make the crimes that we do take seriously a little bit disrespected under law if we start elevating things like this to a felony. I mean, selling unstamped cigarettes is a felony in Maryland. I point that one out frequently because to me, it's a glaring mismatch in the law. That doesn't strike me as nearly as serious as some of the other offenses that are misdemeanors in the state.
Yeah,
We've
I
had
think our
task forces
code-
on this topic.
Yeah, our code is full of unusual things like that. We certainly could do some house cleaning. We just don't seem to have the time usually.
Delegate Grammer, then Delegate McComas.
Thank you, Mr. Chair. I just wanted to ask, what was the concern last year? What happened to the bill? I remember this one from last year.
So we got into a big discussion. So the bill was trying to legalize some evidence coming in also last year. And I think that aspect raised a lot of questions. People wanted to know how and under what circumstances that should be allowed. And I think folks had different experiences on different ends of those kinds of dynamics. And so again, I tried to bring a softer touch this year. But again, I think if you see the bigger bill coming in, it's attempting to allow people who are victims of abuse in some way to bring in evidence of it. But even that became controversial because again, we were talking about, well, is that going to come in criminal, civil? Might it, pop up in a divorce or custody dispute? And that conversation it has its own set of dynamics, I think, that float differently from how we treat the felony misdemeanor classification. And again, I tried to do that too. It just the Senate wasn't interested again, at least as of last year.
Let me ask
Delegate Grammer, a lot of the family law lawyers are always very concerned about this, not looking at it from my angle, but from their angle in the divorce case. Who's recording who and who's playing what and who's setting who up. And we hear a lot of that behind the scenes, even though we're just trying to concentrate on the domestic violence and sex abuse.
So if we, let me ask you another question. Put the admissibility of evidence aside. We're talking about like secret recordings here. Isn't there I don't like felonies on anything. Yeah. I get the general desire to minimize penalties to the best of our ability. Is there no personal type of communication where we just say, look, it's it's prohibited. You could just completely destroy somebody if you record this without their knowledge, and then it becomes public purview and you can't reel that back in. I just want to see how you feel about this.
So it's really hard to find middle ground, because when we're talking about a recording in a domestic violence case, that's probably taking place not only in your home, but probably in your bedroom. And so if we try to draw lines about what's private, you know, how do you distinguish between a recording where, you know, the spouse says, I'm going to punch you, and then the police show up and the person has a black eye, but doesn't want to cooperate? You know, if I could play that recording, I might be able to win that case with an excited utterance of I'm going to punch you, or a statement of a defendant, and then a body camera showing a black eye. So it's really hard to draw lines about what is super private and what's not, because a lot of this stuff does take place in privacy areas.
Okay, thank you.
Delegate McComas.
Thank you, Mr. Chair. I think you're right. This is a complicated issue. And I guess I just want to ask Mr. Schellenberger, okay, let's say George Floyd incident happened in Baltimore City, and the law was the same as it is now. Would that testimony of the camera and him saying, I can't breathe, would that have been able to come in if it was just the not the cameras the police use, but the observation, the folks standing on the curb filming this and recording it?
So the video would be admissible. The audio technically would be committing a crime in Maryland, a felony. Now, certainly a prosecutor could make a decision not to try that or prosecute that case, but certainly a judge saying that that's a crime theoretically could decide to suppress the audio and not let you play it. And we have had those occasions where we've had a recording where the judge will let us play the video, but not the audio, because that's a crime. Remember, 38 states allow one-party consent, which is why we see all these videos on the national news, but not necessarily on the local news.
Well, I guess I would like someone to comment about the fact that there's always the law of unintended consequences, and certainly in serious situations where there's the potential of bodily harm, severe, bodily harm, or abuse of a child, that should be an exception to the two-party consent, definitely. But what I'm kind of concerned about is if we have only one-party consent, we've got way too much craziness on Facebook and TikTok and Instagram and everything else. And also, I think it's going to be used in highly volatile situations, let's say really bad domestic situations where it's going to play gotcha. And so it's going to be who's going to outfox the other. And I do know that I don't think the law enforcement could put a GPS on your car unless they have a warrant or they have a court order that they can do that. So I guess
that's correct.
Yeah. So I guess what I'm worrying about is the balance of these two things and the law of unintended consequences. So does anybody want to comment on that, or am I just kind of like worrying about stuff that isn't a problem?
No, I would love to go back to last year where we had, very specific exceptions for sexual offenses and domestic violence. I thought last year had crafted a nice place. I think Delegate Moon is being very realistic in trying to take, baby steps and getting us going. I mean, let's just think about it, folks. I mean, 38 states allow all this to happen. Maryland is a one-party consent state. Every day, we are potentially making someone a felony when we pull these phones out. You go everywhere, people are recording everything. Our law should kind of reflect what our society has accepted. I mean, I don't mean to get too philosophical, but I mean, it just doesn't make any sense that the average citizen is breaking the law and committing a felony all the time. And frankly, nobody's prosecuting them. So you might look at me and say, well, why should we change it? Let's keep it a felony until, I mean, I think our laws should reflect what our society is going through and what we act like.
And let me also just say, you know, to put that back into your question, stack this offense up with all of the other crimes that come through this committee. This is nowhere near among the most serious of offenses that we hear testimony on. And yet there it is in law as one, the penalty is far more severe than I think what people get for far more serious misdemeanor offenses. So again, this, you know, as has been noted, this law is from another era. And I think, you know, again, ask yourself whether you would have chosen out of the list of all the crimes that we deal with this as one of the ones that comes with, you know, student loan, firearm issues, and that employers need to be super suspicious about you.
Well, I think the only thing I worry about, and I know is the issue of the right to privacy. And so basically you are taking away some right to privacy for folks if you just say it's one party consent and that's it and off we go. So, you know, I think that it's a double-edged sword, and I think we need to realize that. And, you know, if someone doesn't want to be recorded, they're not going to have that option. Okay. They're just not going to. Now we can hope that maybe it'll make us more a more civil society if it's only one party consent, because we know that if, you know, I'm not going to, you know, yell and scream at Delegate Moon, you know, you kill my bill, you kill my bill. But because, you know, he could be recording me. But the point is that I think it does have some unintended consequences. So
that was last year's bill, though, you're talking about. This bill doesn't do any of that. This bill is just about the misdemeanor classification, not one party consent.
Oh, so you're not, well, okay, but then if it's a misdemeanor,
you may later see a bill on that does what you're talking about, but
okay,
not this one.
I guess I'm ahead of the game. Okay.
This bill still carries, or the penalty would still be potentially 5 years in jail, which I think is probably more than enough incentive for people to still not record somebody without their consent, even if it's no longer a felony. But to touch on something that State's Attorney Schellenberger said, as a reminder, again, 38 other states are one-party consent states. So I understand the concern about if we were to switch to anything even close like that, or is everybody going to run rampant and record everybody and hold it over everybody's head? But we can look to these other 38 states. It's not a theoretical question. That doesn't happen all the time in these 38 states. And if this was a big issue, we would see those 38 states trying to become one-party consent states like Maryland is. But that's not really happening because I think most of these concerns are just hypothetical, but don't really play out in reality. And the last point I want to make to touch on that this law was crafted before cell phones and iPhones that can record everything all the time was even conceptualized. And I want to read from my court transcript from my probation hearing. The judge themselves said on the record, as counsel is aware, the laws of the state constantly are trying to play catch up to what the current technology is and how that has changed versus what was contemplated even 10 to 15 years ago in terms of what technology was and what occurred. So that's the judge, you know, speaking on the record saying that this law was made before this technology even was invented or existed. And maybe we should think about how to modernize this.
Well, and to put a finish on that, the statute has the word switching station in it. I mean, there haven't been switching stations in decades.
Well, is it possible? What did you say? Switching states?
Switching stations. I mean, it actually contemplates old switchboards. That's when this law was written.
Gotcha. Okay. Quick question. Is it either Delegate Moon or maybe the library or NCSL, if we could kind of know what the penalties are in the other states as far as a misdemeanor and, what the fine is or what the jail time is or both, that might be helpful to persuade me to not be.
Yeah,
so
I can take a look at if anyone else has classed this as a felony. Thank you.
Okay, thank you. Thank you, Mr. Chair, for being so lenient with me.
Okay, everybody. Delegate Bartlett for the last question on this bill.
Thank you, Mr. Chair. And actually, State's Attorney Schellenberger and kind of addressed my question, and that was, I was going to ask him if he had, how often he prosecutes folks under this statute. So since he answered that question, and since I'm supposed to have a question, what about your friends or other state's attorneys? Do you find that they often, in other counties or jurisdictions, do you find that they prosecute under this statute much?
Not regularly. Not regularly, because everyone has the same problem that I do, and that is we really like to use it as evidence. And so you don't want to prosecute so many people that people are even reluctant to record that domestic violence. So it is not regular, either here or anywhere else.
All right, that concludes the testimony on House Bill 272. The bill that the chair made light of is probably not taking a lot of time because there were going to be 3 witnesses. So now we're going to thank everybody for their testimony on that legislation and go to Delegate Moon's other bill, House Bill 209. And this is the bill that does have 8 witnesses. And the chair is going to have to step away after I start this off with Delegate Moon. So so the vice chair is going to be running his first hearing. So you all are going to have to behave or try. Let's just go with try. House Bill 209 will have Delegate Moon for 3 minutes, then Carrie Williams, CP Hoffman, Lisa Jordan, Steve Kroll. I think it makes sense to do them as a panel, and then Jessica Garth, Gavin Potashnik, Devon Johnson, Bradley Clark can be on the second panel. There is one person testifying in opposition. I will come back as soon as I can. All right, the vice chair.
Thank you, Mr. Chair. Colleagues, this bill should be familiar to you. It's a pretty close redo of legislation you've heard before. The voting sheets reflect a near unanimous vote, both in committee and on the floor. And it was a simple bill to take out antiquated crimes in the Maryland Code that had been used to target LGBTQ residents. And the bill as introduced now repeals the vague crime of perverted sex practice, unnatural and perverted sex practices in the code. By way of history, that prohibition in the code lies next to some bestiality crimes traditionally. And some number of years ago, the courts had ruled that between the sodomy and the unnatural and perverted practices crimes, you could not charge these legally against consenting adult behavior. So they sat on the code, not usable for that purpose, but theoretically usable for other purposes. So a few years ago, the Humane Society and animal advocates started revising the bestiality code to try and add in new penalties like banning people from owning animals. At the time, I asked if we could also clean up the other LGBTQ targeted crimes, and everybody said no. We didn't want to screw up the bestiality bill by bringing an entirely separate conversation. Wait till the next year. We did that and passed the bill that you see before you, which repealed both sodomy unnatural and perverted sex practices crimes. In doing so, we spoke to the animal advocates, the people who deal with sex assault and children's sex assault, and felt quite comfortable, including an Attorney General's review, that everything else we wanted to prosecute was covered. And so we moved forward this bill, again, nearly unanimously in committee and on the floor. The Senate, at the last second, changed it. And so the sodomy part repeal moved forward, and the unnatural and perverted practices part did not. We were told not to worry, that that was never used against gay men, and that wouldn't happen. And in fact, the next year, that's precisely what happened. And so I am back now to pass the bill again as we previously passed it, and close out both parts of the law. Again, with the understanding we've already passed all this language, these provisions, they've been looked at, and everything else is covered. If anyone has any questions about what you are and are not allowed to do with animals in Maryland, my office has compiled a list, and I can send it to you if you need a refresher. Happy to do that. And with that, I will pass it to my panel. And I guess at this point, I'm also taking over. So on the first panel, we are going to have Carrie Williams, CP Hoffman, Lisa Jordan, and Stephen Kroll, and we will go in that order. But I guess before we turn it over to them, does anyone have any questions for me? All right, great. Let's go to the panel then. Carrie Williams first.
Thank you. Thank you, Vice Chair Moon and members of the committee. My name is Carrie Williams, and I'm here on behalf of the Maryland Office of the Attorney General. The Attorney General urges this committee to issue a favorable report on House Bill 209. The statute prohibiting unnatural and perverted sexual practices is a relic from a time when Maryland criminalized consensual sexual activity between adults. It has a discriminatory purpose and cannot be enforced as written. Repealing the statute will not create a gap in Maryland criminal law. All of the non-consensual and commercial sexual practices that can be prosecuted under unnatural and perverted sex practices are criminalized elsewhere in the Maryland Code, as I detail in my written testimony to the committee. What's more, I can say as a criminal appellate attorney that's been practicing for 16 years, charging and prosecuting a statute that cannot be enforced as written increases the possibility of mistakes being made that can result in appellate reversal. For example, I examined the 17 cases where there have been convictions for unnatural and perverted practice between 2016 and 2018, and I'm happy to answer more detailed questions about those if any members have any, but I will say that of the 5 cases that went to trial, there were sentences imposed for the unnatural and perverted practices count in 3 cases. In 2 of those cases, the unnatural and perverted practices sentence was vacated on appeal because it should have merged with another sentence for another conviction. But the court made a mistake because the statute cannot be enforced as written, and that makes the merger doctrine more complicated. So the result was the defendant's overall sentence was reduced. The statute prohibiting unnatural and perverted practices serves no prosecutorial purpose. This bill was careful in ensuring that anyone convicted of unnatural and perverted practices cannot expunge that statute post-repeal. And if they were ordered to register as a sex offender, they will continue to have to register post-repeal. The statute is vested from a discriminatory past and should be repealed. The Attorney General's office urges this committee to issue a favorable report on House Bill 209. Thank you.
Oh, sorry, I was waiting for the chair, but he's not here. Thank you. We're going to go to Lisa Jordan, CP Hoffman next.
Thank you, Vice Chair. Thank you, members of the committee. CP Hoffman again, Policy Director at Free State Justice. Many of you have heard me talk about this issue before in 2020. I really want to hit on something that Carrie just mentioned briefly, which is that this law is, if you look at it in toto rather than just what's enforceable, it's almost entirely unconstitutional. Like, it prohibits oral sex. It prohibits an undefined, unnatural, or perverted sexual practices. It's something that, like, you could not be passed in 2022. And, you know, I find it hilarious that somehow we consider oral sex to be an unnatural or perverted sexual practice in the Maryland Code when over 80% of adults in national surveys, you know, cite having had oral sex, and including like 73% of, you know, people 60 to 69. So it's like a huge portion of people. And not just to talk about oral sex, but like, this is really what the provision is concerned with. If you look at it, the first thing it does is prohibit oral sex for everyone under all circumstances. And that's just frankly ridiculous in 2022. It's unconstitutional. And the only reason that this law still exists at all is that the Court of Appeals has narrowed it so much that there's just a tiny little bit that's still enforceable. And the Senate Judicial Proceedings Committee didn't have time in 2020 when, as you likely all remember, you know, we shut down early because of the COVID pandemic. They didn't have time to sort of address everything with this bill and resolve all concerns. And so they, you know, in their hurry, decided to leave this in. We've seen over the past year, though, that it's still being used. There was a case in Hartford County last year where 4 men were arrested for unnatural or perverted sexual practices. They were taken to the jail. They were held overnight. And then eventually the prosecutor decided to drop the charges because they were unconstitutional. But that doesn't change the fact that they were taken to, you know, jail overnight, that they have these charges on their record.
Your time is about winding down.
So, you know, I really think that it's time to repeal this law, and I encourage a favorable report on HB 209.
Great. Next, we're going to hear from Lisa Jordan.
Thank you, Mr. Vice Chair. Again, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 209 because only sex offenders should be charged with sex crimes, and the people who are having consent are really not sex offenders, and this law is now simply offensive and disrespectful. Regarding 3 things: animals, force, and children. As Vice Chair Moon has already explained, the General Assembly has already addressed the provisions regarding bestiality. You move those provisions into 10606, much better place for them. It allows the courts to order the offenders away from animals, keep them from having pets, all of those sorts of things. Those provisions in the current law are no longer needed. Regarding force, it used to be that sometimes these provisions were useful in cases where it was difficult to prove that the victim had physically resisted. You've actually eliminated the requirement for physical resistance. So we've really taken care of that. Additionally, you've also expanded prohibited sexual activity to include a wider variety of coercive activities in 3709. So again, you don't need 322 anymore. And finally, let me just address children, because I want to thank this committee and the House for passing this bill previously. As my colleague at the bar, Ms. Hoffman has said, the Judicial Proceedings Committee did not pass the bill, and that was out of concern that somehow this would reduce the tools we have to prosecute sex crimes. The Maryland Coalition Against Sexual Assault is completely and totally clear and confident that this bill does not reduce the tools you have to prosecute sex crimes against children. You have plenty of provisions that will fully protect those things. Additionally, just in case there was concern about this, there are some additional language added this year. So when you took out unnatural and perverted sex crimes, we inserted other language that's simply general. And so that should take care of that concern. For those reasons, we ask for a favorable report again on House Bill 209.
Thank you. We have one question for this panel from Delegate Cardin.
Thank you, Mr. Chair. I can call you that now. Just very quickly to Ms. Hoffman, you were indicating that actually this statute was used to actually prosecute somebody or a couple people in Harford County, and they were in the privacy of their own home and doing their own, or in their own private area,
Yeah,
and they were
so
still prosecuted?
so they were charged. The prosecutor ultimately decided not to go forward with the prosecution. What had happened was there was a sting on an adult bookstore in Harford County that had rooms that they rented out where people had consensual sex. And during the sting on the bookstore, the police arrested a number of people, including people who were in these locked rooms, engaged in that were, locked private rooms where they were engaged in consensual sex acts. The acts were not criminal under anything other than the unnatural or perverted sexual practices bill, because they were, again, consensual and in private. So the prosecutor ultimately decided that it was not something that he could take forward because it would be unconstitutional. But again, these individuals had to go through being
they were
arrested.
They were processed, they spent a night in jail,
Yes.
all because of something that we should repeal anyway. Okay,
Exactly.
thank you.
Thank you, and I apologize. I missed Mr. Kroll in the last panel, so we'll stick him first on this coming one. So we're going to call the next panel, and it will be led by Mr. Kroll, and hopefully we've got Jessica Garth from the Prince George's State's Attorneys, Gavin Potashnik from MSAA, Devin Johnson from Lambda Legal, and Bradley Clark from the Public Defender. And if everyone is there, we'll go ahead and get started with Mr. Kroll.
Mr. Vice Chair, good afternoon. My name is Stephen Kroll. I'm the Executive Director of the Maryland State's Attorneys Association and the State's Attorney Coordinator for Maryland. I've been prosecuting cases for 38 years. And Delegate Moon, Vice Chair Moon, it's a pleasure to be on this panel on your side. So I welcome my first bill this year with you. And I just want to tell everyone here that make no mistake, whether they look at the Senate hearing or this hearing, the Maryland State's Attorneys Association asked for a favorable report and is in strong support of House Bill 209. My esteemed colleagues that are on this panel will be happy to answer this question, including Mr. Potashnik, who did prosecute the case in Harford County. But I'm happy to answer any of your questions, and we'd ask for a favorable report. Thank you all very much.
Next, we're going to go to Jessica Garth.
Good afternoon, Mr. Vice Chair, members of the committee. My name is Jessica Garth. I'm the Chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I'm here to show my strong support for House Bill 209 on behalf of State's Attorney Aisha Braveboy and the MSAA, and to ask for a favorable report. House Bill 209 would repeal the unnatural or perverted sexual practice statute, which is an outdated and unnecessary statute, as you've heard from many of my fellow panel members. As a prosecutor, my job is to seek justice, and unfortunately, the statute leaves the door open to injustice. And not only that, it's inefficient because there are already statutes that cover all of the illegal activity that would be covered by this statute. And in fact, many of the penalties covered by these other statutes are steeper and I believe more appropriate. Because of this, I again urge you to issue a favorable report on House Bill 209, and I urge the repeal of this statute. Thank you very much.
Thank you. Now we're going to go to Gavin Potashnik.
Good afternoon, Mr. Vice Chair, members of the committee. Gavin Potashnik, Deputy State's Attorney for Harford County and representative of the MSAA. We too support this bill, and thank you, Delegate Moon, for bringing it forth. Everything that's been said, we agree with and have already been said, so I don't want to add anything else. And with that, we urge a favorable report. Thank you.
Great. Next, we're going to go to Devin Johnson.
Good afternoon, Vice Chairman and members of the committee. My name is Devin Johnson, and I'm a paralegal at Lambda Legal. We are the oldest and largest national LGBTQ legal organization in the country. We also stand in strong support of House Bill 209. Lambda Legal served as lead counsel in Lawrence v. Texas, the landmark Supreme Court decision that was struck down, or which struck down as unconstitutional a Texas statute that's similar to the one at issue here today, that was used to criminalize persons of the same sex for engaging in consensual intimate sexual conduct in a private setting. Section 3-322 provides law enforcement with the vehicle for ongoing discrimination against LGBTQ people in Maryland, as demonstrated last May at the Harford Video and Bookstore. where 9 men were arrested, 4 of whom were charged under this statute. LGBTQ people are already subject to disproportionate criminalization by police. Lambda Legal's own research report, Protected and Served, found that many law enforcement entities still operate under policies, practices, and attitudes that have historically characterized LGBTQ people as criminals. So the statute issue is a glaring example of such a policy that exacerbates the criminalization of LGBTQ people. The Maryland legislature must repeal these laws to protect LGBTQ people from further discrimination and harassment by law enforcement. House Bill 209 is a crucial step to address such laws that provide law enforcement with an ongoing opportunity to criminalize, demean, and devalue the lives of LGBTQ people. We urge the committee to support this legislation and to move quickly. Thank you.
Thank you. Do we have Bradley Clark? I think we do not, in which case we have one person signed up unfavorable. That's Mr. Vince McAvoy, if he is with us. Mr. McAvoy? Yeah, you are, Mr. McAvoy, you're muted.
Am I on now?
Yes, thank you.
All right, thank you so much. I've been looking at this stuff for 10 years. I have never seen anything. I really encourage all the delegates to read my testimony, where I provide some links on this issue. I have never 10 years seen this. I want to read from what was covered back a couple of years ago, and this was in 2020 also. There was a man with, let's see, get to the right place here. Man wearing a dress said this. He said, perverted sex practices. This undefined term shoved into the end of the things, but his words, not mine. Category of crimes against nature, where they also put in bestiality, sex with minors, and just some other things that were just seen as icky and gross, and were some kind of, and he used air quotes here, unnatural. Used air quotes to say unnatural. Sponsors panel went on to talk about animal abuse versus perverted act. I really, really encourage all the delegates to read what I had to write about this. And in closing, because I know I don't have a lot of time in the opposition, I submitted about 6 links. I'm going to read them. This is what happened just since you all last met last year. Transgender arrested in ladies' room, child porn. Loudoun County, Virginia, pushed LGBT pedophilia books in library. Washington Post readers revolt kids to be exposed to kink at pride parades. That directly involves this bill. Don't listen to them when they say that all of these loopholes are covered. That's a lie. They're talking about illegal. That's not what's going on here when you're talking about that issue. The left has a pedophilia problem, and it's been out in the open. And Matt Walsh, we're coming for your children. I do thank you all for listening. I did not want. Thank you for your time.
Thank you. Are there any questions for this panel witness? All right. That concludes that hearing. We are going to go now to House Bill 267. There are 12, this is Delegate Karen Lewis Young. There are 12 witnesses signed up. There's going to be 3 minutes for the sponsor on this one and 2 for the witnesses. Let me see. Yeah, okay. Why don't we go ahead and have Delegate Young, and if she wants to call any of her opening panel after her, we can do that or do them separately. But Delegate Young, why don't you go ahead?
Thank you so much. Nice to see my colleagues on Judiciary again. This bill creates legal protections for healthcare workers. Maryland is only one of 15 states in the country that does not have these protections. You're going to hear from a number of stakeholders today about some very specific cases throughout our state. However, I want to share some big picture data with you so that you'll see some of the trends that were developing even before the pandemic. Since 2011, the Department of Labor shared the fact that there's been a 60% increase in the attacks of healthcare workers. In 2018, the same department did a study which showed that 3/4 of all workplace assaults occur in a healthcare setting. A nursing organization also did a study, and their results showed that 3 in 10 nurses surveyed said that they had been threatened. And that was just this past September. That's up from 2 in 10 last March. So we had a real issue with threats on healthcare workers even before the pandemic, and the pandemic certainly exacerbated it. We've seen departures of healthcare workers, healthcare officers all over the country. It's not unique to Maryland, but we all know it's hurting Maryland. Our healthcare workers are overwhelmed, and now they're frightened because of the threats. We've gone from 2 years ago where they were celebrated as heroes, and now they're being threatened. So, as I mentioned before, you're going to hear many details from the stakeholders, but at a time when we're facing such a critical shortage in healthcare workers, we need to boost our attraction and our retention efforts. And one way to do it is to give them some kind of protection. Thank you so much. And I open it up to the other stakeholders in any order you would like to call them.
Great. So we have a few in the room. Let's go ahead and we'll have people go in this order. Earl Stoner from the Maryland Association of County Health Officers, Travis Gales from Matro, Bernard Durst from LifeBridge Health, Jane Krinke from the Maryland Hospital Association, and Michael Sanderson from MACO. So if Mr. Stoner, if you are there and would like to begin, you're ready for you.
Thank you. Good afternoon, Mr. Vice Chairman and members of the committee. My name is Earl Stoner. I'm Health Officer for the Washington County Health Department. And on behalf of the Maryland Association of County Health Officers, I'll be speaking in support of House Bill 267 today. So as was mentioned, we're at the forefront of many issues, but obviously the big elephant in the room is since March of 2020, we've been at the forefront of the COVID-19 pandemic. And during that time, many things have been implemented, and understandably, there have been members of the community that have not agreed with the methods and some of the recommendations that have been utilized. And unfortunately, some are acting out in harassing, abusive, and threatening behaviors. Really, the level of harassment and intimidation from some, obviously not all, but some of the members of the public during this time has really been unprecedented, as the delegate spoke about. As health officers, our recommendations and decisions are not about controlling people at all. They're based on science, they're based on evidence, and they're based on best practices. We realize, obviously, that these decisions may not be accepted or liked by all, but they may be needed in these situations to save lives. Personally, I've received written and verbal threats. I've been harassed and intimidated in public. I had a child harassed at school. And in response to these threats, I've had to have a security system put in place. At my home, I've had to have law enforcement and security patrols, and other health departments or health officers, throughout Maryland have received similar, and in some cases, even more threatening behaviors. Currently, a law exists to protect elected officials from threats and harassment, but there's no existing law to protect appointed officials such as health officers. It would be ideal to see public health officials afforded comparable protections to those protecting elected officials, namely up to a $2,500 fine and prison sentences of up to 3 years. But although more limited, the conditions set forth in House Bill 267 really are a step in this direction. So in closing, we understand and respect the fact that the public has opinions, but we just really need the protections afforded by other public officials as we move forward. So thank you.
All right, thank you very much. Now we're going to go to Travis Scales for 2 minutes. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Moon, and other distinguished members of the House Judiciary Committee. Thank you all collectively for your efforts to keep the residents of Maryland safe and for taking up this bill. I stand before you today as a former health officer for Montgomery County, Maryland, and a former colleague, Mr. Stoddard, as well as a member of Maryland Association of County Health Officials, and I stand in support and speak in support of this bill. The landscape within which I and many other public health officials took our roles on was to protect and serve residents, performing many duties that historically have gone undetected and unnoticed by the general public, including restaurant inspections, population health initiatives to curb chronic disease and increase access to care, and ensure that we protect the general public from disease through disease interventions and investigations, contact tracing, and vaccination programs. We were and are aware that these jobs do carry potential public-facing responsibilities and are subject to appropriate legal frameworks, policies, and statutes to determine the scope of these roles and responsibilities. COVID brought much attention to our jobs, tasks, and roles of public health leaders across the country. For the first time, there was heightened attention to the decisions being made, many of which followed long-standing public health protocols. During the early stages of COVID, many of our efforts were celebrated, and healthcare providers and workers were hailed as heroes. That tide began to turn as conversations about reopening were had and opinions became extremely politically charged. Threats began being made across the country, from armed mobs showing up at the Secretary of Health's home in Ohio, dismissals in Florida of officials over the release of data, and lots of heated conversation at the national, state, and local levels about the merits of public health perspectives and measures. And if you'll permit me, I'd like to read a sampling of some of the email communication that I personally received. And I'm reading this as this was one of the reasons that was triggered a sense of different tone and rang the alarm on multiple levels of concern. So I will blank out any of the offending language. That there's lots of it within this particular message. Here it is, quotes. I was born in Silver Spring, and the majority of my family is from there. You are the prime example why some white folks call Black folks the N-bomb. If ever there was a picture that should be attached to the definition for added clarity, your selfie is it. You blank blank. I would say blank blank blank, but I'm sure you have blank blank off of your chin on the regular, you stupid primate. No, a PhD doesn't make you smart. It makes you ignorant in your case. Your mother needs to be smacked in the mouth for blank blank blank. I would say your dad needs blank, blank, blank too, but we both know you don't know him. That's what happens when your blank, 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 blank mother is blank, blank in the back alley for blank, blank, blank.
And that's about time also.
I'm sorry?
You're about at time also.
I just want to add that as testimony to what others have to say, is that we're at a point where we do need protections to allow our health officers, public health officials, and health officials and workers to be able to work safely and execute their duties and roles and responsibilities to keep our residents safe. Thank you for the opportunity to be with you, and happy to answer any questions.
Thank you. And yes, I heard about this in news, so sorry to hear that, and thank you for your service. Next, we're going to go to Bernard Gerst, if Mr. Gerst is here.
Good afternoon, Mr. Chair and members of the Judiciary Committee. My name is Bernie Gerst. I'm the Assistant Vice President for Security for Lightbridge Health, and I'm here to support House Bill 267. You've already heard it articulated about the increase in violence in physical assaults and threats in our healthcare facilities. Hospitals and physicians' offices and pharmacies and clinics and other sites are open to the public, and they should be places of refuge and service for people who are sick and seeking medical care. But unfortunately, these acts are increasing in both occurrences and severity. But workplace violence encompasses more than just physical assaults and injuries. It includes threats. The Joint Commission on Accreditation has defined workplace violence as an act or threat occurring at the workplace that can include any of the following words or actions: bullying, sabotage, sexual harassment, physical assaults, or other behaviors of concern involving staff, licensed practitioners, patients, or visitors. So who gets threatened? All personnel can be subject to threats in the healthcare setting. Clinical personnel, such as physicians, nurses, and therapists, and other types of staff, such as transporters, admissions, financial counselors, social workers, food services, environmental services, security officers, and the list goes on. Healthcare workers are being threatened or assaulted for things like enforcing visitor restrictions or masking requirements, or simply asking a disorderly person to leave the premises. The examples you've heard so far have been COVID related. I can give you examples of things that have nothing to do with COVID, like a surgeon being threatened by a former patient because he wasn't happy with the way the procedure turned out, threatening to come back and shoot the administrative assistant and the surgeon on the spot. And other examples of surgeons waiting to go into surgery and being told by acquaintances of the patient that if that patient doesn't live, they're going to kill the surgeon. So it permeates across the system, and there's numerous examples of these things happening. What are we doing to try to help?
Time's about up.
We're putting in place our practices and our procedures to try to reduce workplace violence. I would ask each and every one of you, if you were subject to these kind of threats, would you be shaken or rattled, and would you be able to concentrate on your job after having one of these threats made? So I'm sincerely asking you to support this bill. Thank you.
Thank you. Next, we're going to go to Jane Krinke from the Hospital Association.
Thank you. Good afternoon, Mr. Chairman. My name is Jane Krinke. I'm testifying on behalf of the Maryland Hospital Association's 60-member hospitals and health systems in support of House Bill 267. As you probably know, Maryland is facing a staggering healthcare workforce crisis. There are more than 3,900 nursing vacancies statewide, and there's a 50% increase, which is a 50% increase since August. Our healthcare heroes have been on the pandemic front lines for more than 700 days now. And on top of those challenges, they continue to face rising occurrences of workplace violence. The CDC National Institute for Occupational Safety and Health and the U.S. Department of Labor include threats and written actions intended to control or cause death or serious bodily injury in their definitions of workplace violence. House Bill 267 rightly extends those protections for health officers and hospital staff to include threats made against them, which is in alignment with some of these national definitions. We know that violence in the workplace takes a toll. It leads to higher staff turnover, absenteeism, deterioration of employee morale, and burnout. So we support the intent of House Bill 267. We do have a few recommendations just to make sure it's broader. Some of the threats can occur against any hospital staff, not necessarily those just providing personal care or medical treatment. So we would recommend broadening the definition to include anyone employed by a hospital. In addition, the language around official duties kind of mirrors more so a local health officer. So we would recommend a small modification to reference an individual practicing within their scope of practice or assigned job duties. Hospitals' top priority is the safety of their patients, staff, and visitors. As Mr. Gersh shared and Mr. Smith will testify to later, hospitals and health systems are making every effort to make the patient and employee experience as safe as possible. House Bill 267 offers a tool to help support and retain our healthcare heroes and encourage those considering careers in healthcare. And for these reasons, we ask for a favorable report on House Bill 267. Thank you.
All right, great. Next, we're gonna go to Michael Sanderson from MACO, and then we will take questions. Mr. Sanderson.
Thank you very much, Mr. Vice Chair and committee members. I'm Michael Sanderson with the Maryland Association of Counties. I echo things that you've heard from the sponsor of this bill, whom we applaud, and the other supporters whom we very much agree with. I'll just say that every year MACO goes through a process where we get dozens and dozens of ideas of what ought to be MACO's top issues for the legislative session. The year we're in, our legislative leadership, our elected officials at the county level felt that protecting our public officials needed to be on that list. So we'll fight the fight on multi-million-dollar issues and questions of authority, all that sort of stuff that MACO is known for, but we need to have their back. There's a big part of this bill that is about those who are engaged in public health, the health officers, and the folks who are on the front lines during this pandemic and otherwise. That's the message that this bill sends. This is not the sort of law where we're going to send a whole lot of people to jail. What this law does is it says, we've got your back. Folks who are in public health, folks who work in these health facilities didn't sign up for this kind of treatment. Maryland already provides this sort of protection for a list of elected officials. We've already decided that's good policy. When you commit a crime like this, if a violent threat or intimidation that would impede someone's doing their own work in public health, that's a bigger thing than yelling at your neighbor about, the apples falling on my lawn. It's just a bigger thing. We support this bill. We thank the sponsor. Delighted to work with the committee on this bill. And we anticipate having another one before you that's got a broader application before this committee later this session.
All right, thank you. We have two hands up. We're going to start with Delegate Fisher and then Delegate Barakan, and hopefully you can ask a question to one of the panelists or sponsors specifically.
Okay, thank you, Mr. Chair, Mr. Vice Chair. I guess this would be either for the sponsor or Dr. Gales. I think it kind of goes off of what Mr. Sanderson just said. And for me, I think laws on the books that are not going to be enforced. My question to you all is, does the healthcare community want to receive the support of, yes, we passed this misdemeanor infraction, but what is the conversation been with our state's attorneys and others to actually enforce the law? I think for me, I totally, the bill is a great bill and I support it. I think, you don't want to tell people they're protected and they're not. And so I think, you do want to bring charges forward is actually my perspective. When people are doing this, and when you have something that's a misdemeanor infraction, the bill has, I think, only 90 days and a $500 fine. You are then in this bill asking prosecutors and district court prosecutors, so that's like a newer young prosecutor, to be bringing these in the district court on a docket and folks to come in. And I wanted to know what kind of conversations you were having and what kind of enforcement of this law you're looking to have. Because my tone would be, if you're really going to have their back, you actually want to then actually have charges and proceed to charge and actually prosecute individuals. And so I guess I'm thinking about, is it something like this, or you do something that has like a higher threshold with a higher penalty that you're actually going to pursue? Because I don't know about the message of the MGA saying we support people and then we don't actually show up. And it's another empty law that's not enforced. So that would be my question.
Well, I'll respond. The penalties that were designed in the bill were based on best practices. There are 35 other states that have similar laws on the books, and we looked at those best practices and gave you all a recommendation. Now that the bill is in your hands, obviously it's up to you to decide what you think is appropriate. In terms of enforcement, I'm not sure why enforcement for this violation would be any different than enforcement for any other violation. Once it's a law, it's up to law enforcement to enforce it when and if it's reported. And the third point I would make is that I do think, sorry for the barking in the background, they always pick when I'm on voice to do it. The third point I would make is, yes, it does make a big statement to our healthcare community who are suffering from incredible stress and fatigue, that we are trying to do something to be supportive of them in an area where they feel the most threatened.
Could I comment on that as well, please? Because I think we missed an important step in between. The victim has every right to make application for a statement of charges, to have that case go before the state's attorney, and every state's attorney has the right to have prosecutorial discretion. But a lot of things happen in between there. There may be a plea deal. There may be, they may get probation before judgment. It may be put on a stat docket, but it makes that statement. And I can tell you that if one of my employees here is assaulted, if they choose not to, if they ask us, we'll make application on their behalf. We'll assist them in the prosecution. And if this law were to pass, we would do the same thing for an assault.
Thank you. Delegate Eric Han has her hand up, and then we've got Grammer.
Thank you, Mr. Chair. Thanks for bringing this bill, Delegate Young. So this happened to me my first session. I got a series of voice messages when I was sitting committee. If the chair was here, he might be able to remember when I shared them with him. Lengthy messages about lots of expletives and how I was going to be killed, blah, blah, blah. Anyways, it was passed along to law enforcement. Nothing ever came of it. So I'm not sure what special protections we have, but I don't feel that that's true or really being implemented now for us. Did the previous bill that was submitted, did that include health officers? Because I do remember a bill, but I don't think it included health officers. And the reason I ask is, including them, and I don't know if this is the intention of your bill, in at least one of my counties that I represent, our health department is really our councilmen and women. So I feel like the language of the bill could actually include them, since they're the ones making a lot of the decisions. And was that intended to sort of protect all of our councilmen from upsetting their voters?
I can speak to some of the nuts and bolts of that, if I may, Mr. Vice Chair, that might be helpful. I can't speak to the prior introduction of another bill. I can say, Delegate, you're correct that there's a special role for the governing body of most counties. They sit as the Board of Health. And in most of our counties, either the county council or the county commissioners serve in a dual role as the Board of Health on behalf of the county. And the state law provides a variety of roles and so forth for them in their capacity as members of the Board of Health. I don't think that under this bill, a county commissioner or council member would receive new protection in those roles, but they already enjoy current protection. You'll see that this bill creates a section under criminal law 3708.1. The current 3708 is the law that is designed to protect you all as elected officials, county elected officials, and a pretty short list of others that includes state's attorneys and public defenders and their assistants. I think that's as far as that list goes. That's what we want to address in another bill later this session. So you had a tool because of your station as an elected official to potentially act on the threats against you. This bill is trying to seek something comparable for folks like, Health Officer Mr. Stoner, who spoke earlier.
And Delegate Young, do you recall whether the previous bills included health officers? I feel like they didn't. I feel like this is a new addition.
I don't know what was in the previous bill. I had a bill last year, but it never got to committee. I included health officers because I was looking at the audience of our public health departments that are part of our county government, but they report to the state. And at least in the past 2 years, they've been as much, if not more, on the front line than other healthcare workers, with the exception of hospital workers.
Yeah, and maybe EMTs, fire and EMT. I mean, did you think about including fire and EMT or police in this?
I had a real dilemma about making the scope huge or trying to narrow the scope. And I decided to keep the scope narrow because that was the original motivation. It actually came from a constituent of mine. I went out and researched how frequently it was occurring. And so I decided to try to keep the scope of this particular bill to healthcare workers.
Okay, I appreciate your answers. Thank you.
All right, Delegate Kramer.
Thank you, Mr. Chair. Thanks for coming today. I wanted to ask, do you think imprisonment is actually justified in this bill with what is an exceptionally low bar? I mean, if you read this and with the intent to intimidate, interfere, or impede, I mean, there's a lot a person can do that can be in a court of law considered intimidating, interfering, or impeding, especially considering what many of the health officials did to people when COVID hit. It was pretty damn intimidating. And frequently cops showed up to your business and they said, you're going to shut down right now or we'll arrest you. And I don't know if anybody has any experience with this, but when COVID hit, like people went illiquid very quickly. They had no money. And they said, how in the hell am I going to pay my bills? And some of the mandates that came down from the health officials, like the child care providers, they got a letter that said, you're going to have to adjust everything you do within 24 hours, or you're going to shut down and you're going to sign this, and that's it. So everybody that I talked to that had to work under one of these mandates felt completely threatened. And the difference here is like they didn't have any authority. They basically had no idea how they were going to live their life or pay their bills or operate their business. So, you know, these kind of people really got put in a pinch. I'm sure many of them acted out of frustration or fear, and intimidate, interfere, or impede, you know, in a little bit of anger. Anybody could do that. So
In the form of a question.
Is jail time necessary with that exceptionally low bar?
I have a book here, a binder of stories from all over the country. And this bill allows for some flexibility. I can tell you that half the stories include something more than harassment, threats of death, not only to the healthcare worker, but their families. One nurse was told that someone was going to kill her children. So I think you have to have some flexibility for the worst case scenarios, as well as something that might be perceived as being minor. Somebody was stressed out in an emergency room and became loud and angry. And that's why the penalty says up to. It's up to whoever is determining the sentence to match it to the severity of the case.
If that's the justification, threatening death is punishable by law in Maryland. So, and look, I have a book of people from my district, their personal stories where they got put through the ringer here. So with that aside, knowing we have lots of laws that apply to healthcare workers or healthcare officers or elected officials or the average non-government employee, we have laws that protect against these things. So why in this case, this is my problem here, why are we going to create a new crime that we don't think is going to be enforced with a really, really, really low bar with a criminal penalty?
Well, I don't agree that we don't think it's going to be enforced. I'd like to be more optimistic than that. And I would ask you why 35 other states believe it's necessary. And there's efforts at the federal level to do something similar. We have a growing problem. It's been going on for a while. I think I shared a statistic early in my testimony that workplace violence and threats were characterized as occurring 75% of the time in healthcare settings. So that statistic alone would suggest that we need some very specific protections for healthcare workers.
But that bill is not this bill. We've heard that bill. We've heard from the hospital workers say assaults, physical assaults are going through the roof.
Delegate Grammer, I'm going to say we should move on to the next question. We have a whole other panel after this and another bill.
Okay, thank you, Mr. Chair.
Thank you. All right, let's flip over to Delegate Cox for a question. Please, and then we'll flip to the next panel. Thank you.
Thank you, Mr. Chair. And I just wanted to ask two quick questions. First of all, Delegate Young, good to see you today. Does it, in fact, expand the definition of a threat to include intent to intimidate, interfere with, or impede? I'm reading the statute. The reason why I asked, I'm reading the statute, and I don't see that in the statute. So that's my first question.
I believe that is included, yes.
Okay, so with that expansion, would you be open to including the police as an amended entity within this new section of health officers? So that if someone intimidates, interferes with, or seeks to impede the police, that they also would be able to be prosecuted?
This bill, as I mentioned before, this bill is confined to healthcare workers. It is now under the jurisdiction of your committee. What you choose to do with it, whether you want to expand it or more narrowly defined it, is in your ball court.
So with that, if someone were to say, F the police, would they be able to be prosecuted if we added them in?
If you want to do a separate bill for that, certainly.
Okay, nothing more. Thanks so much, Mr. Chair.
Thank you. All right, we're going to bring the next panel up. We have hopefully Larry Smith from MedStar, Beth Resnick from Hopkins School of Health, Brooke Torton from UMD School of Law, and then we've got a favorable with amendment from Joanne O'Gatis from the Nurses Association. If we can all bring them up, and we will start with Mr. Larry Smith if he is with us. Go ahead. Larry Smith. You can go ahead.
Thank you.
Yep,
Thank you,
go
Mr.
ahead.
Chair. I'm sorry, I had some noise. Let me just turn this off. Thank you. Thank you, Mr. Chairman. I appreciate your time in the committees. I know, once again, it's been a long afternoon. My name is Larry Smith, Vice President at MedStar Health, and I'm here to testify on behalf. Can you hear me?
Yep, you're good.
Thank you. Thank you. I'm here to testify on behalf of MedStar Health in favor of the bill.
Mr. Smith, we're told you should turn off your live stream. It sounds like the live stream audio might be competing with your Zoom audio at the moment. Oh, did we lose him? Okay, we may have lost him. Let's we can come back to him. Let's skip over to Beth Resnick.
Hello, thank you. Can you hear me?
Yes.
Okay, great, thanks. My name is Beth Resnick. I'm a senior scientist in the Department of Health Policy and Management at the Johns Hopkins Bloomberg School of Public Health, and I'm here today in support of the bill. From death threats to protests and even shots fired at their homes, public health officials across the country as well as here in Maryland, have been the focus of attacks that have added to the already immense pressure they are experiencing as they do their jobs to prevent illness and death. In the first 9 months of the pandemic, our research identified over 1,500 incidents of harassment across the country, and this harassment is continuing. A CDC study of public health department employees in 2021 across the country, 26 respondents reported experiencing stigma or discrimination, 24% reported being bullied, and 12% reported job-related threats. Here in Maryland, as we heard earlier, all 24 local health officers have experienced some forms of harassment during the pandemic, ranging from angry emails and social media messages, protests at their offices, public meetings, and even their homes, and have received personal threats to them and their family members in places such as the grocery store or even directed at their children at school. Some of these attacks also reference their race, gender, religion, and sexual orientation. Public health officials in Maryland and across the country have came to public health committed to saving lives. They are now leaving in the wakes of attacks and harassment, depleting, demoralizing, and stymieing our own public health departments just when we need them the most. Since the start of the pandemic, 7 Maryland public health officers have left their positions, leaving us without critical public health leadership just when we need it most. This legislation can protect public health officials to do what they were hired to do, protect and promote the health of all Marylanders. I urge you to give a favorable report. Thank you.
Thank you. We are now going to go to Brooke Torton.
All right, thank you. Good afternoon, everyone. My name is Brooke Torton. I am an attorney. I work at the University of Maryland Carey School of Law and a few different grant-funded programs, namely the Legal Resource Center for Public Health Policy. I'm here in my individual capacity to testify in support of HB 267. In my role with the Legal Resource Center, I have significant and frequent contact with public health officials nationwide, but significant contact here in Maryland as well. Like we've heard from the other folks who testified, there's been a significant increase in threats and harassment aimed at, I'm going to speak about the public health official side of it. I don't have as much contact with healthcare workers, so I'm referring to public health officials. So initially, to determine what protections exist, and we heard Delegate Lewis Young spoke some about this. I'm the one who conducted that 50-state survey to determine what other states have done, and I've attached it with my testimony. 35 states and Washington, D.C. have a law which criminalizes these threats, the harassment, and the obstruction of duties when a government official is trying to do their job. Many of the states have broader laws, but they encompass public health officials. Maryland and 15 other states, we are in the significant minority. The vast majority of those 35 states, they're generally misdemeanors, and the penalties are really similar to what we see in this bill here. I also just want to mention, I believe Mr. Sanderson referenced this as well, that we do have a law, Criminal Law 3708. It's very specific to local elected officials and some state officials. That is also a misdemeanor, and that has been enforced. I don't know about how significantly, but it has been enforced and used certainly over the years. The state's attorney's office has taken up some of those cases. And so for this reason, I would urge you to issue a favorable report and allow Maryland to join these other 35 states and Washington, D.C. by sending a clear message that public health officials are worthy of these same protections that we offer to other government officials. Thank you.
Great, and it looks like we've got Larry Smith back, so we're going to skip back to him and then close out with Joanne Ogaitis. Larry Smith.
Mr. Chairman, thank you so much. I apologize for the confusion. My name is Larry Smith, and I'm with MedStar Health. I'm chair of their Associate Safety Committee and also Vice President for Risk Management. MedStar Health supports the intent of this bill, no question about it. It's really needed. However, since threats can occur against hospital staff who do not provide personal care or medical treatment to patients, we recommend broadening the definition to include any individual employed by the hospital. MedStar, like many other healthcare systems in Maryland, if not all, have taken a number of steps on our own to try to prevent workplace violence in our workplace, but we need your help. These efforts have not proven enough to abate the kind of problem that we're seeing. Let me just tell you a couple of things that MedStar, and again, other healthcare systems have done too. First of all, we have developed an electronic system for reporting incidents of workplace violence. This is really important because workplace violence is very much underreported. Even all the statistics you heard today about the numbers that we see pale in comparison to the actual reality of what's going on. Nurses and doctors either don't have the time with all their schedule to be reporting these, or fear that there's some reason if they report them, it could cause problems for them. So we're working real hard to make sure that our staff knows we want to hear from them. We've also actually provided de-escalation and defensive physical skills training to over 2,000 associates working in 3 high-risk areas: security, emergency medicine, emergency rooms, as well as behavioral health. And believe it or not, even in our OB unit, where some of the worst kinds of issues of workplace violence have been seen, it's amazing that we're having to train our own staff to defend themselves physically while they're on the job. We've implemented many training programs for our associates. In addition to that, 30,000 associates are slated for training in de-escalation. Anybody within our organization should know how to accomplish that when they face these kinds of escalating issues. And we've also distributed a training module, training video, as well as intensive training around active shooter. So we literally are dealing with issues of life and death, in addition to the kinds of harassment we see that is on the other end of the scale. This is not just a healthcare issue, it's a public health issue. One of the things I'm very concerned about is nurses and doctors are in short supply, not just now during the pandemic, but they will be later on after the pandemic is over. We're seeing more and more who are out of work because of serious injury, more and more who are leaving their job, leaving their profession, no longer interested in working in healthcare because of the risk. And so, Mr. Chairman, with that, MedStar urges the committee to act favorably on House Bill 267. And again, thank you very much for the second opportunity to talk.
Thank you. All right, we're gonna go now to Joanne O'Gatis, and then we will take questions for this panel.
Great. Mr. Chairman, members of the committee, my name is Josie O'Gaitis. I've been an RN for 20 years, and I've worked in 3 large healthcare systems in Maryland. My opinions are my own and that of the Maryland Nurses Association. Verbal threats are a weekly occurrence in the acute care setting. Physical threats monthly. I've seen nurses kicked, punched, spit upon, carts overturned, computers thrown, and threats posted on Facebook Live. Nurses report irate family members saying, "I'll be waiting for you outside when you're done your shift." And what ticks them off? It's common reasons: pain meds not given, long wait times, ambulance patients being seen before waiting room patients. Lately, it's the no visitor policy because of COVID. Hardly reasons that justify threats to the same medical team that's trying to save lives. Nurses de-escalate and they apologize, but there are times when none of that works and the aggressor continues escalating until someone gets hurt. It's demoralizing for the healthcare team. We live in a healthcare culture that accepts horrible behavior with no consequences. Violence is underreported and occurs in all settings: nursing homes, urgent care, private practice, residential facilities. Patients or family members, they act out because it works for them. They get what they want, and then they repeat the same disruptive behavior at the next hospital. They know the staff can't turn them away because we're bound by EMTALA. The frontline reports that aggression is hitting an all-time high due in large part to the pandemic. Traumatized healthcare workers want to leave the front line, they don't want to come back, and it's further contributing to the workforce shortage. Passage of this bill sends two clear messages: to the victim, that they're supported; second, to the aggressor, that their behavior is not okay. The $500 fine would create strong incentives to not be disruptive in the first place. The fine would be linked to the offender, jeopardizing their reputation in the community, and it would serve as a deterrent to repeat bad behavior. For more serious threats, this bill would make it a crime. Physical assaults happen way more than most think. One ED nurse told me she was threatened with a knife. The bill would make this a criminal offense without the difficult road of assault. Everyone wants to do something for health professionals right now, given the stress of COVID, and passage of this bill is something that the legislature can do. We thank you for your support and look forward to working with this committee.
Thank you. Are there any questions for this panel? Okay, seeing none, that concludes that hearing. We are now going to move, I believe, to the final bill of today, House Bill 225. This is also Delegate Karen Lewis Young. I believe this is a redo on the 2-minute, 1-minute schedule. And I also believe we have only, we have 6 people signed up on this. A few favorable and some unfavorable. So why don't we go ahead with the sponsor and then we can go from there. So just a couple minutes.
I'm
Okay,
sorry,
thank-
Mr. Chairman. I'm sorry to interrupt Delegate Young. Mr. Chairman, we have one person in opposition for the previous
Oh,
bill.
I'm sorry.
Okay.
I am sorry. I spoke too soon. We are not going to be ending that hearing. I believe our one opposition is Vince McAvoy. Yes.
He's coming in now.
Okay.
Can you hear me all right?
Yeah, go ahead.
All right, thank you so much, committee. On this bill, as it reads, this doesn't help some of the people that were listed by the hospital employees. People sweeping floors aren't covered by this bill. If you go to Franklin and MedStar, they're going to tell you that they want all of their employees to actually help those patients when they come in. This bill is focused on state employees and health officials. Okay, so the fact that these issues with COVID are brought up kind of highlights the issue. We've already had this problem with violence against hospital employees. This was brought up a couple of years ago in a bill basically allowing companies to file a domestic violence hearing for their employees. So they get to do that now. That's all covered. If they're not doing it, then they're not, and they're having threats and so forth, then they're not doing that piece that you just passed a law to fix. What this would do was basically any state employee, that works in the health department, I guess that would include floor sweepers, they get covered. So if somebody for some reason threatens them, they get covered. Why is this coming up? Well, in Frederick County, we had some discrepancies about how COVID was handled. It is not even arguable that some of the issues implemented because of COVID in the state and other states across America were unconstitutional. Biden himself admitted this last April. So people are upset and they're going and saying these things are wrongful. So if the state employees have to hear that, so be it. We have a constitution, we have rules. If they want to change it, they go to you guys and they change it. Until they change it, until the constitution's changed, they have to abide by that. So if they make unpopular decisions, they have to live by that. But this bill, when you're talking about these nurses and so forth that are getting threatened because of addiction, because of, just improper acting, this bill's not going to help them. And when Delegate Young says this is narrow, that's just silly. It's just silly. This is an extremely wide scope bill, and the point was made when you talk about other people who actually are in harm's way all the time. Those folks need to be looked after. I do agree that we shouldn't have people threatening people in hospitals. So if we have to get security guards to help them, and we say, look, this is what we're going to have to do, then let's do that. This bill, it's really not on the mark. Thank you so much for your time, committee.
Great. Is there any, are there any questions for this witness? Okay. Now, I'm back on the correct schedule. We are going to shift over to House Bill 225. Again, Delegate Karen Lewis Young, 2-minute, 1-minute for sponsor and witnesses. Delegate Young, why don't you kick us off?
Thank you. You are correct. You all heard this bill last year. It was voted at a committee unanimously. It was voted on the House floor unanimously. The Senate never got to it. In order to refresh your memory, it's a very simple bill. It came from a constituent who had been sexually assaulted. Her case was not brought forward, which happens the vast majority of the time. In addition to the trauma she suffered from the assault, She was also traumatized by not knowing why. What this bill does is require the state's attorney's office to explain to the victim why their case didn't move forward. We worked it out with our local state's attorney's office to tweak the timing of that conversation. Everybody was on board. So I would like to turn over my extra minute to my subject matter expert, Lisa Jordan.
And she's also the person signed up in favor. So Lisa Jordan, why don't you go ahead?
Thank you, Vice Chair Moon. Thank you, Delegate Young. Again, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. The Maryland Coalition Against Sexual Assault represents all the rape crisis centers across the state of Maryland. We also have the Sexual Assault Legal Institute. We provide representation for survivors all across the state. And so we're here in support of House Bill 225, in part because we work on these cases all of the time. I will confess that the bill makes me a little sad that we have to legislate having a prosecutor explain why they're not going forward on a sexual assault survivor's case. But I am here to confirm that we do. We represent over 400 survivors every year. Many of them want to know about criminal charges, talk about it, and those who have already filed criminal charges, their biggest complaint is often that they just didn't know what happened. Keep in mind that Maryland is the state that had 6,000 untested rape kits. So this is unfortunately a trend and something that as a policy matter, you all should consider. I'd also just like to point out that for every 1,000 rapes that occur, 9 go to a prosecutor. That's 9 out of 1,000. That's because so many are not reported at all. And then when they are reported, they're often not brought to the state's attorney. So by the time you get to that place where the prosecutor's figuring out how to charge and whether to charge, it's a very small number. It's a reasonable bill. We urge a favorable report on House Bill 225.
All right, thank you. Any questions from members for the sponsor or witness? Okay, if not, we are. Well,
Mr. Chair, I'm sorry, I do have one question. For Ms. Jordan, if I could, please. Couldn't it, it's a broader question. Couldn't a prosecutor not bring a case because he didn't have sufficient evidence, he or she did not have sufficient evidence?
Yeah, thank you, Delegate Grammer. Of course, absolutely. I'm not suggesting that every single case should be brought forward. I'm suggesting that prosecutors should have the human decency and respect to just say that to the survivor and explain it to them, human being to human being.
Does that make the case vulnerable if they wanted to pursue it in the future?
I don't think so, no. I think that if you say to a survivor, right now, today, we don't have enough evidence to go forward, and then there's additional evidence that comes to light, that's easy to explain. That certainly happens.
Okay, thank you.
All right, great.
I think you're muted, Mr. Chair.
Oh, I'm sorry. We do have some folks signed up to testify in opposition. Do we have Stephen Kroll, Joe Riley, or Gavin Potashnik here? All right, they're coming. Mr. Kroll, if you are, I see your name on the list. If you're here, we're going to call you first, and then Mr. Riley and Potashnik in that order. So Mr. Kroll, whenever you're ready.
Mr. Vice Chair, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. And I'm here to ask this committee to vote against House Bill 225 and ask for unfavorable report. No one on this panel, whether Mr. Tashik, Mr. Riley, and I, we are pro-victim, pro-witness. And in fact, Ms. Jordan knows if she has a problem, she has to call me. Maybe there was somebody who didn't call somebody. Maybe it happened, and I'm sorry for that victim or witness. But we do not want to legislate policy. I voted against plea bargains. because it's policy when this committee wanted to put plea bargaining and codify it into law. This should not be codified. If we made a mistake, again, I apologize to the victim or witness. No one is stronger on victim witness rights than I am. But to codify it makes no sense. What is the penalty if we don't do it? There is no penalty. If Ms. Jordan or anybody else, the sponsor, has a problem where someone is not communicating with the victim or witness, this committee knows me. They can call me immediately and I will get in touch with the state's attorney. I'll get in touch with the assistant state's attorney. But to codify policy is the wrong way to deal with single problem. If there are many problems, we will deal with it. And I ask the sponsor or anybody else in this committee that puts a bill in affecting state's attorneys to call me, and I'm happy to talk to them and happy to try to resolve the problem without legislation. And for that reason, because it should not be codified, we're asking for an unfavorable report as to House Bill 225. Thank you.
All right, next we've got Joe Riley.
Thank you, Vice Chairman Moon. My name is Joe Riley. I'm the state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We seek an unfavorable report on this House bill. Simply as my colleague, Mr. Kroll, stated, you are codifying policy here. Is it a good policy? Absolutely. It certainly is a good policy, but it shouldn't be codified. Just like it's a good policy for members of this delegation to call back constituents when they call them about bills or something. It shouldn't be codified that you do that because you're responsible to the voters, just as we are responsible to the voters. If there are examples of this, they should certainly make an issue of it to the state's attorney, make it an issue in the election. That this isn't being done. This state's attorney doesn't support victims. And it should be handled in that way, not with a statute that, quite frankly, is just this is a policy you should have, and we're going to make it a law.
All right, and next we've got Gavin Potashnik.
Good afternoon, Mr. Vice Chair, members of the committee. Gavin Potashnik, Deputy State's Attorney for Harford County. I just want to make clear, more informational, we already do this in Harford County. In fact, I work in the CAC, the Child Advocacy Center. Part of our accreditation hinges upon making sure that we have sufficient victim contact. We do that with all of our victims in all of our cases. And if we don't, and the state's attorney hears about it, he gets very upset, and he's beholden to the voters on this. And I don't want the community to have the impression that state's attorneys across Maryland are deliberately ignoring their victims, particularly in cases of sex violence, because we know that these are cases that involve a lot of trauma, a lot of emotion, and we do everything we can to make sure that our victims, whether they contact us or not, are apprised on every step of the way. And that is our policy. So, I'm not sure why we need to enshrine this policy in legislation. And I'm certainly open to working with Delegate Young and any other member of the committee to make sure that we enforce our policy. And for that, I'll ask for an unfavorable report.
All right, we've got questions from Delegate McComas and then Bartlett.
Thank you, Mr. Chair. This is a question for Mr. Potashnik. Gavin, you explained something which which said is kind of a problem for the bill, and it was that the state's attorney's office may not know. Someone may tell the police, "Hey, I was assaulted" or whatever, and it just never gets. Nothing's filed. The victim doesn't file anything. The police don't. They maybe don't believe the victim or something. So, can you explain what you're concerned about with that dynamic? Because you were pretty, we had that discussion the other day.
Certainly, and I think the dynamic is really for those counties that have state's attorneys embedded with officers and in their own kind of units, right? We have direct communication with our officers because I'm embedded in a unit where down the hallway, I have a detective who works on child abuse cases. So we have a lot of communication. There are some counties that don't have that. So when you don't have the communication, this bill, one of the unintended consequences is it could drive a wedge between law enforcement and prosecutors because the police then are absolved of their responsibility to also explain to victims as to why they never forwarded a case to the state's attorney or why they never, or why they never followed up. Or the police will just forward everything to the state's attorney's office regardless, and they won't use their own discretion as to whether or not there is a chargeable case, which could further complicate matters when we come to the subject of who talks to whom. I don't really have a problem taking the mantle of talking to victims so long as we are sufficiently apprised of all of the facts in any sex abuse case. And that's that can be a problem sometimes when it comes to these types of cases. And again, I know it's an overly simplistic kind of view on this, and it's not meant to in any way dissuade anyone, but it is a problem that could happen out of this.
Thank you.
All right, Delegate Bartlett.
Thank you, Mr. Chair. My question, I have one question for the state's attorneys and one question for Lisa Jordan. My first question is, while I understand Harford County does it right, what I don't understand is there may very well be, based on, if you heard Lisa Jordan's testimony, 991 people who don't know, 991 incidences where the state's attorney or the prosecutor failed to prosecute, okay, for whatever reason. And I get that. My question is, 991, doesn't that seem to be an extreme amount of phone calls to a state's attorney's office to keep asking, what about this case? What about this case? What about this case? I don't know, either whichever person wants to answer can answer.
I may have heard Ms. Jordan's testimony, but I thought her testimony was out of 1,000 rapes that occur, only 9 are ever reported. So those 991 are never reported to police. So there would never be a call to those people because people have no knowledge of that, nor would there be law enforcement knowledge of that.
Okay, so I misunderstood that. So
I
then
may
I'll
have
go.
misunderstood it. That's what I.
Well, I do have a question for Lisa Jordan, so this will give her a chance to clarify. If you could clarify that, and then if I could ask my other quick question.
I don't think she's with us in the room. So unfortunately, that panel has passed.
I did have a question. I did put my hand up for a question for her. Well, then let me ask my question to the state's attorneys then. Whatever the number is, where in the state of Maryland, where there is a failure to prosecute or decision not to prosecute in a matter in which someone has claimed that they have been sexually assaulted, whatever that number is, am I hearing from you all that while it is not recommended to codify policy, which is what we do all day long, but while it is not recommended to codify policy, that you would prefer Lisa Jordan or other advocates or our office to contact you every time we get a victim who says, I have no idea why this particular case was not prosecuted? Is that what you were saying?
Sure. Absolutely.
I guess that question is for each one of you.
Yes, if Delegate Bartlett, if you have an instance where a constituent says, I've heard nothing from the state's attorney's office, I would certainly hope that even if this was passed, you would pick up the phone and call us.
Here's my problem with that. We're doing that right now. And I know this is a different agency, a different ballgame, but we're doing that right now with unemployment. And quite frankly, I'd rather have the agency, meaning the state's attorney, I'd rather have the state's attorney's office notify individuals, especially with the sensitivity of sexual assault cases, that the case is not being prosecuted and why. And I mean, I don't see why that is a complicated thing to do. I don't understand it. Maybe you all can explain it to me.
Well, it's just simply, we don't support any codification of policy, just like there's quote unquote tough on crime delegates that come here every year and say the state's attorney shall not enter into plea deals on certain charges. We argue against that too, because those are policy decisions. We're elected. Now, in your situation, when you're talking about unemployment, that's an unelected official. Maybe a law like that would be appropriate for that. But we're elected and we're responsible to the voter. So if there's things happening in our jurisdictions that our citizens, our voters are not happy with, they're going to fight to have us removed from office. This bill—
But that doesn't fix the problem. That's just that individual. And Mr.
But this
Chair,
bill doesn't fix the problem either. You pass a law that says what? We have to do this.
Delegate Bartlett, I welcome anyone to call me. I think I have a good enough relationship with this committee where I welcome the calls. I'm putting myself out there and welcoming the
I've
calls.
got you on speed dial. I've got you on speed dial already, but thank you. Thank you, Mr. Chair, for indulging.
All right. Thanks, everybody.
Mr. Chair,
Yes.
somebody had a question for Lisa Jordan, and she was putting in the waiting room. She's willing to come back in if you'll let her to answer Delegate Bartlett's question.
Delegate Bartlett, did you get your question sufficiently answered?
No, I didn't, and I would love for her to come back, please. Because I never got a chance to.
Well, we're unfortunately not able to make that precedent stick.
No, but here's my question,
we
Mr.
can
Chair.
follow up afterwards after the.
Okay, but did we ever have an opportunity to ask questions to her? I never saw that opportunity. Because I put my hand up and I put it down because we had the opponents come in.
We did.
Okay. All right, no problem. I've got Lisa on speed dial too. I'll ask her.
All right, appreciate it. All right. Well, thank you, colleagues. That is the final bill of the day. We'll be back Thursday, I guess, for fiscal briefing at 11 and family law related bill hearings at 1. So that ends.